This is one thing. She goes, why they have it there? We're taped today on the off position.
Perfect. So you're still checking or no?
Jill just so. Yes.
I'm okay. Yeah, I'm okay. It's in person. And that would be here. All right.
I know. I'm not waiting to the very end. I'm not, the script is written, but you can, after the minutes, you can introduce me. I'm not gonna take long, but I don't want to wait to the end. I'm gonna make a motion. Yeah. I will make a motion.
I don't know whatever happened to that.
Right.
Follow it up.
Good afternoon.
Vote on variance. You get to be present.
Good afternoon. We have a quorum of members present this afternoon.
But we can vote.
Excuse me one second, please. And the New York City Board of Correction, good afternoon. We have a quorum of members present this afternoon. And the New York City Board of Correction, July 8th, 2025 meeting is now in session. Our first order of business is a vote on the agenda for today's board meeting, which board members have received. Will a board member move for a vote to approve the July 8th, 2025 meeting agenda?
Motion to amend the agenda.
There is a motion to amend the agenda. Is there a second?
Second.
Okay. Thank you, Board Member Stasso.
Can I speak in favor of the motion?
Okay, what is the motion?
I would like to amend the agenda to allow, after the minutes are read, to allow me to give a brief statement, because this will be the last meeting that I will be present at my last meeting of the Board of Corrections. And I know that it's a long meeting, and I've been to hundreds of them, probably. And people tend to leave at the end, and I want to address the people who were here rather than the people who left. So I would appreciate a vote in confidence saying that I can speak directly following the reading of the minutes.
There's a motion on the floor that's been seconded to amend the agenda to allow Board Member Cohen to address the audience. I'd just like to note that towards the end of the meeting, there was going to be time for that and comments. So we'll go to a vote on that. All in favor of the motion?
Aye.
Okay. I'm going to object to the motion. But the motion passes.
Okay, thank you.
Now, will a board member move to approve the July 8th, 2025 meeting agenda as amended?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Okay. Does any objections? Does any board member have edits or comments on the agenda? Okay, and so we had approved the July 8th, 2025 agenda. Mhm. Okay. So, Dr. Cohen, your statement will come out after the approval of the minutes, okay?
Okay.
Our second order of business is a vote on the draft minutes for the June 10th, 2025 board meeting, which board members have received. Will a board member move for a vote to approve the June 10th, 2025 board meeting minutes?
So move.
Is there a second?
Second.
Does any member have edits or comments on the minutes? All in favor of approving the June 10th, 2025 board meeting minutes?
Aye.
Aye.
Any opposed? Hearing no objection, they are approved and duly ratified. At this time, we'll hear from Dr. Cohen. Dr. Cohen, I will reserve my comments on your service to this board towards the end of the meeting. I was trying to give you that moment at the end of the meeting, but as the agenda has been modified, you currently have the floor and your mic is open. If there is a tape over your mic is live and open at all times.
Thank you very much, Chair. My name is Bobby Cohen. I'm going to read this because I haven't memorized it. It is with some sadness that I submit my resignation from the Board of Correction. I am confident that the City Council will quickly appoint an excellent replacement, one who shares my goals and aspirations, and hopefully has a little more energy than I have to continue this important work. It has been an honor and pleasure to serve the Board of Correction and persons inside New York's terrible jails. I hope that the new remediation manager is quickly selected and acts rapidly to take control of the jails. Time is clearly of the essence. 40 deaths in the 3.5 years of the administration, Adams administration, is 40 deaths too many. No one should die in jail. If DOC does not have enough staff to prevent these deaths, the city and state should release prisoners. I have many thank yous to make, and any inadvertent admissions, I apologize in advance. I've gotten tremendous support from so many of you here. I will not be able to name all of you. First, I would like to thank the coalition that formed to limit the retrograde rule recommendations offered by the department in 2006. Most of you probably don't remember, but in 2006, the department essentially presented a set of rules for approval of the board, and a coalition was formed to object to some of those rules. And that coalition asked Chris Quinn, the president of the city council at that time, to appoint me to the next opening, and she did, and I really appreciate that. It is my opinion that no rulemaking should take place under the Adams administration because they will be severely compromised by their commitment to lockdown, solitary confinement, and a so far minimal effort to construct the borough-based jails. That community-based coalition, some of whom are here today, convinced City Council Speaker Christian Quinn to put me on the board. And I want to thank you, coalition and Chris. The New York City Council has been a constant friend and supporter and colleague in my work. They are indispensable and provide critical leadership to our common tasks. The men and women living in horrible conditions on Rikers Island have provided the board with their documented, confirmable stories of gross, continuing flagrant harm they suffer on a daily basis from staff treatment and from confinement in the inhumane dungeons of Rikers Island. I thank the current and past staff of the Board of Correction. Their tireless efforts produce consistent, high-quality reports and information which are essential to the board's work. I note that despite their best efforts of professionalism and collegiality, they sometimes work, not always, but sometimes work in a hostile environment and are sometimes subjected to threats from department staff. I would like to thank those colleagues in DOC and CHS, Department of Correction and Correctional Health Services, who have recognized the board's purpose and regularly provide us with important information which might otherwise be hidden. There is no transparency on Rikers Island today, and there will never be transparency. Many of our friends working for the city on the island provide us with important information which would otherwise be hidden. There are two groups based outside of Rikers Island who play an essential role in supporting board functions. At each meeting of the board, the Prisoners' Rights Project of the New York Legal Aid Society has been present and provided cogent, informative testimony. These attorneys, paralegals, and social workers have been the conscience of our city. Their critical litigation efforts, now manifested in multiple courts, and particularly in the Southern District Nunez litigation, will now result in the swift appointment, I hope, of a remediation manager who will remove the operation of the jails from the Department of Correction and begin a substantial and successful effort at reform. In tandem with the Prisoners' Rights Project, the defense bar of each borough, their lawyers, social workers, and students present us with findings and testimony which allow us to understand the Rikers Island experience by those living there. I would also like to thank the press of New York City. They work honestly, effectively, and relentlessly to report on our jails. The continuous light they shine on Rikers Island is brilliant and focused. The stories they have covered and uncovered make my work and the work of the board so much more powerful. But there are life-threatening problems on the island which the board and our minimum standards have not resolved. This administration, with rare but important exceptions, has consistently promoted cruel and unnecessary practices. Since beginning his mayoralty almost 4 years ago, the mayor has issued an emergency executive order blocking critical board minimum standards. The mayor and the Department of Correction are committed to a policy of maximizing the use of restrictive housing, lockdowns, medical lock-ins, and solitary confinement. Within the past year, without required notification to the board, they established the SMU, the Special Management Unit, another restrictive housing unit which our staff has found dysfunctional and dangerous, probably as intended. For 6 months in early 2023, Commissioner Molina blocked board access to video footage from the jails, one of our critical tools for monitoring. Members of the board retained independent counsel and successfully sued for restoration of full access to video coverage. Finally, Rikers Island is a hellhole. I've been working here for 40 years. It is a filthy, it is a fire trap. There was a recent fire which was very, very scary. Its locks don't lock, and it is dangerous to all who live and work there. CO staff and people incarcerated. Systematically, during this administration, the average incarcerated population has increased relentlessly from a low of 4921 and 21, 5559 in 2022, 5873 in 2023, 6206 in 2024, and 7417 as of May of this year. And that was a 322% increase from April. This is intentional and is planned for in the city budget projections. I will end with a plea. Everyone who can must keep their eyes open and speak out about any atrocities they are aware of in the jail. It's only if the people who know things say things that change can come at a reasonable pace. Most importantly, this board and everybody in this room should be committed to getting people out of the jails and to closing Rikers Island. I just want to thank all of you. And it's been a tremendous honor to serve this board for the past many years, 15 more. And thank you for your patience today. Thank you.
Thank you, Board Member Cohen. Again, I'll reserve my comments for the end of the meeting, acknowledging, your long dedicated service to this board. We will now hear pre-recorded anonymous public comment from people in custody.
Closed captioning is provided for viewer convenience. However, the accuracy of machine-generated captions may vary based on audio quality and speaker cadence. The Board of Correction does not guarantee the accuracy or completeness of the captions. To ensure the safety and protection of individuals using the people in custody comment line, names and inmate numbers have been withheld.
Yes, good morning. My name is Pat, and I'm calling from Rikers Island. My booking case number. And I'm calling regarding our holiday. Today is the Eid, and we're supposed to go and pray. You see what I'm saying? They talk about rumors like tomorrow we're supposed to have a festivity and all that, but the more important thing about the Eid is the prayers, you know what I'm saying? And this is one of the most biggest, I can say, like a holiday when it comes to the Muslim community, to the religion, period. So I feel like they violated me, and all the brothers right here. So, and regardless to this hot pot too, because we don't have no hot water here. They talk about some people throw some water to whoever in another building. So I guess now one person mess up for everybody else. But we buying commissary, we buy coffee, soups and all that. We need hot water to cook our food. So the water and hot. So if someone can basically come and resolve this problem, this issue, and I appreciate it. And there's another thing too about rec. They want to make us drink of water from like a water hole, and that's not right. Even when you put that water in the bottle, you can see that it's not a clean water. We should not drink that, And when we're telling them about that, they feel like we don't know better. They know what they're doing, but really they're not. So if someone can come and handle the situation, those issues, that would be good. I really appreciate you. Thank you.
The caller has hung up.
Hello, how you doing? My name is case number 3 in EMT Center. That's Eric M. Taylor Center, also known as the 6th Building. I'm calling because I was involved in an incident or wrongfully accused of being involved in an incident that happened back on May 24th, 2025. I was PhD and sent to the box the very next day after being served with a ticket on the 25th of May, 2025, and sent to Rosie's box, which is RESH, Rosie Enhanced Supervision Housing. I was there for 10 days before I was released on beating the ticket and beating all charges, found not guilty. And upon leaving there and being returned back to EMTC, which is the 6th Building, Eric M. Taylor Center, they still have me to this day of June 13th, 2025, in the system as enhanced restraint. I don't know why the system have not been updated yet, but it's been over a week, and I believe that me beating my ticket, and it specifically says on the ticket that was written by Cap of Rosie's, that red ID and enhanced restraint is revoked, being that
I was not a participant in the altercation, and I was on my bed the whole duration of the incident. The incident happened in 7 Upper, in the AMT Center, Eric M. Taylor Center, the 7 Upper Housing Unit. Everything was recorded on camera, and you can clearly see me sitting on my bed, never leaving my bed. But again, I've been out the box for over 10 days, and I'm still in the system as enhanced restraints, which is causing me to have to be monitored or handcuffed whenever I need to go anywhere in the building, even down to legal visits with my attorney, which doesn't look good on my. I ended up even going to court from Rosie's, and it doesn't look good for anybody's case coming in restraints and orange junctions. I would gladly appreciate if this is further.
Yes, my name in case it's 3. It's a couple of things. First is one, be 2 per unit, only 1 SBA. And also the SBA that is here is for sentence, and they should be going upstate any moment. They've been sentenced for almost 2 months. So they don't come around and ask for the SPA test or anything. That's about it. Thank you very much.
The caller has hung up.
How you doing? My name is Case number 4. I've been incarcerated in the Rikers Island, which is funny called the Rikers. Since October 7th, 2022. I have no lawyers coming to see me. Nobody advocating for me in the courtroom. I'm calling legal aid services. Our lawyers Russell Ruffler to check the logbooks. Man haven't advocated with me. He's denying to even pick up my call, denying to even come see me. I am not having no representation. Based on a map, we only get law library once in the blue. We barely get rep. Not only that, I put in a 3031A, 1826-2023, which is with a right, exhaust my rights to speedy trial. I haven't got no response back from the courthouse, a lawyer, or CA. My judge is David J. Now, the courtroom every single time. But I'm trying to exhaust my remedies for my First Amendment right. I put a case for us and let them know I don't have no discovery for it. He told 2 years. Violation of Discovery Reform Act that was adopted. I'm not getting any help at the law library. What functions? I have to do everything by myself. I put in 3420 to the Eastern District. It's last 3030 denying the speedy trial because they haven't answered in 2 years. We're now 2025. They haven't answered that either. Now my case doesn't pop up on WebCrib. I'm being told by the general office that you're going to a state hospital, you're waiting to go to a state hospital. A 730 evaluation cannot be done in a corporation like this. It has to be done inside of a hospital. I have never went to a hospital to have a 730 evaluation, which is violation of mental health and violation of other things. I don't understand how am I being told was a state hospital if I never had that done. And I don't have no court dates. I have nothing going on. I don't understand how my case is stressed and it's not popping up on WebCrib. Because I ain't saying that I'm not even found guilty or convicted. 13th Amendment Section 1, if you read it, slavery and voluntary servitude is only for inmates that are convicted. I am not convicted. But I'm stuck on like it's out there. 18 U.S.C. 242 states that you only have one inmates are only supposed to be in jail for less than 1 year or pay $1,000. I paid $5,000. I bailed out. I have to please get back to me as soon as possible. Send somebody to come see this information. I'll give you a copy of yourself where you can see it for yourself. I also did a FOIA Privacy Act that shows proof on Hi, my first name is, my book case number is, I'm at the Eric M. Taylor Center on Rikers Island. I'm in housing unit 11 upper. I'm calling to make a complaint about the medical services that's being provided to me, including the rest of the inmates at the facility. I made a medical appointment since Wednesday, about Wednesday of last week, and the medical staff told me that they scheduled me for sick time, that I would have to wait until the officer escorts me. I haven't been called since. I've been waiting over a week already. I called back sick call on another occasion a few days ago, and they told me that I'm still on the sick call list, and I would just have to wait for officer to put me down. But like I said, it's been over 7 days. I also left a message on medical staff voicemail by calling 614 pound to telephone, and I told them about the issue. Like I said, 7 days, and there's other inmates also that have similar problems. I know the jail is a very big facility, but correctional officers should make a schedule for each housing unit at a certain time each day. Take inmates down there. To get medical treatment in a reasonable time period. I have the next issue that I'd like to focus on direction, but I'll call leave a separate voice message for that. Thank you very much for your help. It's been greatly appreciated. Also, our next issue, in the same jail before, and I also had the same problem at the same jail a while back, where 2 weeks I was seen by medical. Hi, my booking case number. I'm at the Eric M. Taylor Center facility on Rikers Island. I'm in housing unit 11 upper. I just called here a little while ago and left a message on this officer's voicemail. I'm calling back regarding a separate matter. Since I've been in this facility as a sentenced inmate, the staff does not call the library regularly. They only call the library like once a week. Sometimes they call it twice a week. That's it. People that are not sentenced to regular police for the days in other houses, they get law library once a day, except except Sunday and Monday. For those days, the law library is closed. Even with sentenced inmates, even though I'm a sentenced inmate, including everybody else in my category, people should still be allowed to go there regularly just for the detainees, because people might have parole issues, parole violation issues, or open cases, and or they might have different legal matters, pertaining to child custody matters. I have a lawsuit that I'm working on in court, but because of the only court of law library once a week, that's not helping me or the rest of the inmates at all. The rest of the inmates are complaining about it in the housing that I've been in. I really appreciate the office looking into this matter. Thank you very much for your help, and have a very good day. Bye-bye.
Yeah, hello. My name is Zion here at OBCC 44. Yeah, I would like to let you know I'm at one upper. We've been being denied a chance to go to Sick Hall heavily every time I've been trying to get down to there. Because it comes to my attention that the clinic here, the New York City Health and Hospital Clinic here, is still doing the all sick call close out thing from the last lawsuit that happened in Legal Aid Society versus New York City Health and Hospitals in 2024. Yeah, they're still doing that where we're directed, like me, the person in custody is directed to call 614. You call 614, and they promise that they put it on the list. Next thing you know, no officer comes around to pick us up. And then, they get to say that they get to close out their decision, and as in that we was never produced. It's not our fault. Second, the OC knows that one upper has been suffering from a heavy lice infestation that needs medical treatment. To properly kill lice and treat lice, you need proper medical treatment and chemicals to do it. But the officers keep telling us that they don't like to do their job, and they don't want to do their job, and we're making it too hard for them, and they just find reasons to be lazy and get around it. So they never produce us to medical, so nobody has to do their job. Yeah, but it's still going on. It's really bad. I have lice on me right now. It's itching. I'm very itchy. I couldn't go down to medical today because the officer swore that I wasn't on a list, even though I called 614 on a recorded line and was promised that I was. They do this to us every day. Did I forget to mention that I'm mentally ill? I'm part of the MO, population here like that. So I have a serious mentally illness, and they still don't want to help us. They still don't want to accommodate for us. They still don't want to give us effective treatment, cream, kill the lice and treat the lice. They don't want to give us clean beds because I've been telling them and everybody that I know, 311 and the Board of Corrections, that the lice live inside our beds. So we're being forced to live on side of these beds that have lice. And they know it, and no one will help us. Yeah, that really sums it up. We being denied medical treatment. We have lice. Nobody's helping us in rec. Rec has not been coming around here for the last month, from June to July. Rec.
Thank you all who have left public comments on our dedicated lines for people in custody. Redacted comments have been shared with the department. All comments associated with a facility have been assigned to the BOC facility monitor and have either been resolved or are being addressed at this time. I'll just make a note for the record. I don't see a response to the last comment for the PIC. So if there could be a follow-up to see what the action was taken on that.
Here. Is there any, have the staff found any systemic explanations for the problems reported here? Okay.
The notes on the follow-up, it doesn't address systemic problems, but that can be added to reporting for future PIC comments.
Thank you.
We do have a citywide official in the audience who will speak now. I'd like to ask New York City Public Advocate Jamani Williams, if he can come forward. I believe he wants to address a number of items that are on the Board of Correction agenda for today. So yes, welcome Public Advocate Williams.
Thank you, Mr. Chair, board members, peace and blessings, love and light to everyone. Afternoon, as mentioned, my name is Jamani Williams, Public Advocate for the City of New York. Thank the Board of Corrections for holding this meeting today. I just want to say it's immensely difficult work that everyone in this room does, from coalition members to correction staffers to legal representatives to health professionals to family members to board staff. Everyone carries a lot of weight. Responsibilities are tremendous, and they're only surpassed by the enormity of the task before us. The back-to-back deaths, less than 90 minutes apart, of Mr. Benjamin Kelly, age 37, Mr. James Maldonado, age 56, truly highlights that there is much more work to be done here still. I want to extend my deepest condolences to the families of these men. Their lives mattered and should have been protected in DOC custody. My purpose has always been to bear witness to highlight the crisis of violence, mismanagement, and neglect, and to advocate for solutions that create a safer environment for those on both sides of the bars. It is clear that what we are doing now is not working. I'll be remiss, while of course death is the worst case scenario, I always want to mention the issues of our correction officers as well, who have been assaulted, and our women who have been sexually assaulted. It's all sides of the bars that are not safe right now in Rikers. I'll now turn to agenda item 6, a limited 2-month variance concerning overcrowding in 3 facilities. While these variances are for overcrowding at OBCC, EMTC, and the West facility are directly tied to upheaval in our state system, these are not simply administrative adjustments. They are accommodations, I believe, for a system that some will call broken. The DOC correctly identifies drivers of our problems. A jail population at the highest since prior to the pandemic. There's a backlog of over 1,100 who should not be in state facilities. We must remain clear. The administrator's priorities are what put the department in the position where any deviation would lead to this sort of crisis. I believe the mayor in particular focus on not decarcerating, but increasing decarceration has caused a lot of this. Continuously approving these variances without a clear and publicly accountable plan will only lead to more continued variances. So hopefully there is a plan in place. Let's just understand what the final destination is. Last year, the local conditional release commission, which is empowered to release people early from jail sentences, began meeting again after 20 years. I've long advocated for releasing people from custody who do not need to be held in detention awaiting their day in court. Overcrowding heightens issues already present in the jails. It increases violence, as we've seen people who are here longer become more prone to violence. Strains infrastructure, makes the delivery and provision of services more difficult, and creates unsafe conditions for everyone. This is especially urgent considering the record-breaking heat wave this city is just experiencing. If folks were hot even coming into this building, imagine how it feels to be locked up in an overcrowded facility, particularly if there's no air conditioning and little air circulation. Now I'll discuss agenda item 7, which includes a status update on restrictive housing units, including the Special Management Unit, SMU, and the Resh Annex. This does look very often and feel like forced isolation to me. Before last week, the courts had spoken, not once but twice, in affirming the city's council's authority and the will of New York's by upholding local law 42, the city council's law to ban solitary confinement or forced isolation for a long period of time. This administration continues to fight this humane and necessary law in court while simultaneously replicating the practice of forced isolation through the units like the ones I mentioned, and the appalling practice of deadlocking individuals in mental health units for 23 hours a day, as brave whistleblowers have revealed. As the board has observed, even in these completely independently crafted units, it's clear that just basic training, planning, collaboration seem to be lacking. They do not rehabilitate, they serve to only deteriorate. I have seen these types of units firsthand and have spoken out against them. This approach, which struggles to provide mandated services, programming, and basic human contact, is not a bug in the system. It's a feature of a system designed primarily to isolate, punish, not to correct, or, in my opinion, to keep people safe. I know even the corrections officers and staffers agree with us around minimum standards and them not being delivered and what it means. I also just want to point out that some of these units and these housing units were created without people having knowledge, and it just shows that a housing unit can be created. When it comes to local law 42, my biggest frustration is that it wasn't even attempted. We didn't even try to do it and come back with what the major concerns could be or any adjustment suggestions. Recently, I visited Rose M. Singer Center at the request of staff and detainees, following reports of cisgendered men being housed in units in the wake of the pause and upstate transfers due to the state prison wildcat strike. This turned out to be true and resulted in a more heavily restricted life for all housed in this facility. Men are locked on the first, second, and third floors, and women on the fourth and fifth, leaving people locked down for longer periods of time in their cells with fewer opportunities to attend programming and services. Rikers Island is a highly stressful environment, making it all the more important that incarcerated people have regular access to recreation time. I'd like to again extend my condolences to the families of those who have died in DOC custody. Recent deaths cannot be forgotten, and it's the charge of this body and my office to ensure this doesn't happen. While Commissioner Magdalene Liddy has been making some strides, I see her efforts and understand that the staff face enormous challenges, many of them infrastructural. Still, we must and can strive to do better. Lastly, I want to acknowledge that it is Board Member Dr. Robert Cohen's last meeting after 16 years of service. Dr. Cohen has been a great advocate for the dignity and safety of people on both sides of the bars, including being a valued ally and advocate for the movement to end solitary confinement and forced isolation in our city's jails. There is no doubt that your work has saved countless lives. I want to extend my deepest gratitude to Dr. Cohen for all his years of service and wish you all the best in your future endeavors. Thank you.
Thank you very much.
Yes, if any board members have questions for you, Public Advocate, if you have time.
Sure. I gave a great speech. I might have answered all the questions.
Could you just maybe, you said you toured Rosie's?
Yes.
Could you just maybe elaborate a little bit more about your experience and what your thoughts?
Interesting enough, corrections officers are the ones that reached out to us. And usually if they're reaching out to me, that means it's a problem. So we get really concerned. We did go to see what was going on. We heard about some shifting that occurred, having men in some of the facilities. And I do know most of it had to do with what was happening upstate in the Wildcat strike. It did appear that the women who were there were getting less services and maybe in their housing unit longer than they may have been. And so it was causing some problems and changes in people's regular routine, which is probably not what you want in a stressful environment. So we were concerned about it.
Okay, thank you. And you know that this board has had considerable concern about the SMU unit. Have you visited that unit as well?
I'm not sure. No, we haven't.
Okay.
We have not.
Yeah, I recommend maybe a follow-up visit to the SMU, you know, and if you have time. And, you know, I'm sure board members here will be happy to join along, those that are available to look at the SMU again.
Absolutely. Thank you. Thank you. Dr. Cohen, thanks again. Thank you, board members. Appreciate you.
All right, thank you.
Thank you.
Okay, at this time, we'll move to the executive director's update. So Jasmine, if you can.
Thank you. Good afternoon, everyone. Thank you for joining us today. Since our last board meeting, there have been 2 deaths in DOC custody. We extend our condolences to the families and loved ones of Benjamin Kelly and James Maldonado. Mr. Kelly, age 37, died in EMTC on June 20th, 2025. Mr. Kelly was found unresponsive in his cell by DOC staff at approximately 2:59 p.m. Mr. Maldonado, age 56, died en route to Rikers Island from Richmond County Criminal Court on June 20th, 2025. Both causes of death are currently pending confirmation from the Office of the Chief Medical Examiner. As with all deaths in custody, the board is actively investigating and will issue a public report on its findings. We also share our deepest condolences with the families of department staff who passed since the board's June meeting. The staff who have passed are retired Officer Alvin Rodriguez, retired Officer Wayne Barrington Stewart, retired Officer Gary Grant, retired Officer Delette Pridgeon, retired Captain Jeffrey DeGrasse, retired Captain Joseph Archibald, retired Captain Ira Finkelstein, retired Officer Raymond Lyon, retired Officer John Leone, and retired Officer Lamont Monroe. Regarding census data, as of July 7th, 2025, there were approximately 7,694 individuals in department custody, a 0.64% increase from June 9th. Broken down by facility as of July 7th, in Bellevue Hospital Prison Ward, 52 individuals, Elmhurst Hospital Prison Ward, 9 individuals, EMTC, 1,753 individuals, GRVC, 1,033 individuals, in NIC, 296, OBCC, 1,628, in RESH, ESH, 147, in RESH, non-ESH, 366, RMSC, 431, RNDC, 1,162 individuals, in West Facility, 819, with a total of 7,694 individuals. Regarding reports, the board issued its report titled Assessment of NYC Department of Corrections Lock-in and Lockout Procedures on June 23, 2025. The board conducted a 6-week assessment of the department's lock-in and lockout procedures to determine whether DOC staff are locking people in custody in their cells during regular lockout hours over an extended period, and whether documentation reflect these lock-ins. BOC staff identified 9, or 18.8%, instances of involuntary lock-ins across 48 housing areas toured during the 6-week assessment. Although BOC minimum standard 1-05 subdivision B, which requires DOC to afford people in custody with 14 hours of out-of-cell time, is currently suspended by mayoral emergency executive order, depriving people in custody of lockout time with no basis or supporting documentation is a problematic and unjust practice. DOC Directive 4009 RC on lock-in, lockout authorizes department staff to involuntarily lock in individuals in custody for reasons such as threats of violence against staff or other people in custody, or incidents that pose a serious and ongoing threat to the safety and good order of the department. The policy is clear that lock-ins should be a last resort when all other alternatives have been exhausted, and lock-ins should be lifted as soon as possible. Board staff will continue to verify if DOC staff are affording lockout according to policy. Some of the recommendations to DOC in the report included: 1, discontinue the practice of unauthorized deadlocking and discontinue using the term in DOC logbooks. 2, train staff and issue disciplinary action to address any instances of inappropriate, individualized, involuntary lock-ins going forward. 3, implement robust reporting requirements across all facilities, including tracking and reporting individualized involuntary lock-ins, akin to how emergency lock-ins must be tracked pursuant to our minimum standards. And 4, ensure DOC staff assigned to mental observation housing areas complete a 40-hour crisis intervention training. The board further recommended that when a person in custody reports an involuntary lock-in allegation to CHS staff, the staffer must report the allegation to CHS leadership and document when this practice impedes access to medical and mental health services. CHS's response is amended to the report, which is posted on our website, and we look forward to hearing the department's response to the report's recommendations today. Next, I'll provide BOC staff observations regarding the Special Management Unit, or the SMU. The SMU is a housing area located at 1 Southwest in OBCC. Per DOC Directive number 4492, effective February 5th of 2025, quote, SMU is aimed at managing incarcerated individuals who pose an unreasonable and demonstrable risk to the safety and security of staff, other incarcerated individuals, the facility, or would present an unreasonable risk of escape, end quote. SMU is distinct from and more restrictive than general population housing because out of cell time is limited to 7 hours as opposed to the 14 hours required by the board's minimum standard, which is currently suspended by mayoral emergency executive order. And individuals are strip searched and subjected to a handheld metal detector scan when exiting their cells during lockout times, which are between 10 a.m. and 6 p.m. Board staff have reviewed SMU's policies, visited the unit, and interviewed persons in custody and uniformed staff, noting concerns about the unit's operations and its impact on the incarcerated population. Board directors conducted a review of mandated service for SMU for the month of June 2025, including observation of recreation, religious services, sick call, law library, and visits. We note the following. Transfers into the unit lack clear and recent justifications, while individuals are removed from SMU without consistent reason or placement reviews. The high number and timing of emergency lock-ins in SMU have substantially disrupted mandated out-of-cell time and frequently overlap with core service hours, which are from 10 a.m. to 6 p.m., raising concerns regarding access to daily activities such as recreation, law library, religious services, visits, and sick call, among other essential services mandated by the board's minimum standards. Individuals housed in SMU are placed in enhanced restraints for all escorted movement within the facility, which may include security mitts, handcuffs, waist chains, and leg irons, even if they are not individually designated to be placed on enhanced restraints. Due to requiring enhanced restraints for all movement within the facility, incarcerated individuals reported struggling to access medical services and other services as limited enhanced restraint equipment hinders their ability to exit the housing area. The department provided access to recreation on 14 out of 30 days in the month of June 2025. And when provided recreation takes place in a small yard previously used for people in custody placed in restrictive housing. Out of 4 expected service days in the month of June 2025, for Jewish, Protestant, Catholic, and Juma services, Jewish services were provided 3 times, and Protestant, Catholic, and Juma services were provided once. The department does not document sick call requests made by individuals in the SMU in a way that allows the board to track who submitted a request, who was seen in the clinic, and why some individuals were not seen. For those who did not attend, there is no documentation of the reason, such as a conflicting appointment, court appearance, visit, refusal, emergency care, or improvement in condition. According to clinic records, clinic visits from individuals housed in the SMU were documented on 8 days during June 2025. However, there were no corresponding entries in SMU's A or B post logbooks, and clinic staff explained that individuals in the SMU must be seen one at a time for security reasons, which significantly limits daily access for the rest of the building. Law library services should have been afforded on at least 20 days in June 2025, excluding Sundays and Mondays. However, individuals housed in the SMU did not physically attend the law library on any of the dates that the law library was open, and law library request slips are no longer being distributed in the SMU. People in custody reported discomfort with the visit process, citing a lack of privacy, constant officer proximity, and restrictions on physical contact with visitors. Officers explain that although the SMU is minimally impacted during some tactical search operations, or TSOs, due to its already limited 7-hour daily lockout, There were days where lockout time was reduced to 0. A total of 3 individuals housed in the SMU were placed on suicide watch during the month of June. Staff reported that the unit, once chaotic and violent, has become more controlled over time. However, both uniform and program staff noted that restraints and security protocols pose significant barriers to service access. Individuals in custody voiced a range of concerns. One person reported being slashed and still housed with rival gang members, expressing ongoing fear for his safety. Several declined participation in mandated services such as law library and visits due to the requirement of full restraints during movement. Others who had been transferred from enhanced supervision housing to SMU felt they were being punished twice due to cumulative isolation time from the rest of the general population. Many also reported not being informed of any support plans or timelines for exiting the unit. Additional concerns included lack of access to shorts, inconsistent linen and laundry services, unaddressed high heat in the unit, and non-private visits with restrictions on physical contact with loved ones. Prior to June 2025, uniformed staff assigned to the SMU reported not receiving any training specific to SMU policies or procedures. They indicated that while they received general training at the academy, there was no additional instruction tailored to the SMU. On June 6, 2025, the department began providing training to staff focused on trauma-informed care and restorative justice. DOC staff have expressed interest in receiving hazardous duty pay, Gate 1 passes, and other incentives for working in the SMU, a restrictive housing unit. The department has assigned an assistant deputy warden to manage the SMU. Warden Barnaby, who has spoken before the board, has been working collaboratively with BOC staff to bring the unit into compliance with the minimum standards, building a partnership with board staff as an additional set of eyes and ears. However, many of the issues within the facility are rooted in broader practices and policies that extend beyond their immediate control. And that concludes the BOC staff updates.
Thank you, Executive Director Jasmine. Any questions for the Executive Director if we move forward? Okay, I just wanted to acknowledge also, we do have Board Member Stasso on remotely. So thank you for hanging in there, Board Member Stasso. So again, thank you, Jasmine. Next, an update from the Chair on the Board 6A Work Release Program Review Committee, Dr. Lauren Stasso.
Thank you, and I'm sorry for not being able to be there in person today. As chair of the 6A Work Release Program Review Committee, I'm pleased to be able to present our report to the board today. The committee's full written report has been shared with board members and will be posted on the BOC website following today's meeting. The committee's mission was to review the department's 6A Work Release Program to understand the department's legal scope of authority and to provide recommendations for optimizing decarceration under the program. Over the past 2 months, the committee has engaged with the department and various stakeholders and assessed the criteria utilized by the department in determining eligibility for admission to the 6A Work Release Program. The committee now submits recommendations for the full board's consideration and approval. These recommendations are centered on applying time limitations to 4 criteria the department considers when determining admission to the work release program. If approved, the board will submit these recommendations to the department. The recommendations are as follows. The department currently considers an applicant's performance in prior work release and probation or parole programs when determining if an applicant should be admitted to the work release program. Our recommendation is that the department should not consider this when the remaining sentence length is shorter than 30 days. For individuals with longer than 30 days left to serve, this assessment should be limited to the applicant's performance within the last 2 years. The department considers an applicant's history of violent criminal behavior indicated by prior arrest charges or convictions for violence-related felonies when determining admission to the program. We also recommend this should not be considered when the remaining sentence length is shorter than 30 days. For individuals with more than 30 days remaining in their sentence, this assessment should be limited to the applicant's history of violent criminal behavior within the last 2 years. The department considers whether an applicant's institutional disciplinary record indicates a history of violent or escape-related activity when determining if the individual can be admitted to the work release program. This factor should not be considered when the remaining sentence is shorter than 30 days, and for individuals with longer than 30 days left to serve, the department should only consider the individual's history of violence or escape-related activity within the last 2 years. Lastly, the department considers an applicant's criminal history report indicating a pattern of bench warrants and/or probation or parole violations. We're recommending again that this factor should not be considered when the remaining sentence is shorter than 30 days. And for individuals with longer than 30 days left in their sentence, the department should limit their review to a pattern of bench warrants and/or probation or parole violations within the last 2 years. Based on the work of this committee, I move that the board approve the committee's recommendations as presented and authorize their submission to the Department of Correction.
And I'd assume that that's a motion that you're making, Chair Stossel, Committee Chair Stossel. And is there a second? And it is second. If you can restate your motion, and then we can go to a vote.
Sure. I'm moving that the board approve these recommendations as presented and authorize their submission to the NYC Department of Correction.
Okay. Are there any questions? All in favor of the motion? Yeah, 1 second. There's one question. Yes, I'm sorry, General Counsel.
Recommendations or had the I'm sorry. We've not seen this report or the recommendations or had the opportunity to respond to this, so I don't know that it's appropriate for the board to vote and make these recommendations without that opportunity. I'd just like to raise that and leave that for thought.
You like to respond to Committee Chair Stossel?
Well, we had a discussion of these. I think, we talked through it a little bit. I think, again, our recommendations are for you to be able to consider. I think this was really an opportunity for us to sort of get on the same page amongst ourselves about what we're recommending as far as the 6A program. And we're happy to have continued discussion or, answer any questions that you might have about it.
Again, as Dr. Stossel just characterized it, we've talked about it a little bit. We haven't seen it until just now, the actual recommendations, the scope of them, how they might impact the program or, other replies that we might have for the board. So I just think, I think this motion at this point is, when we haven't even seen the report, it's not been released, is not appropriate.
I don't have a strong feeling about necessarily doing this today. I think if the department would like to review these recommendations and we can have further discussion, that's not a problem for me.
So, Committee Chair Stossel, if you would want to, as a friendly consideration to the department, withdraw your proposal at this time or your motion at this time, that would be fitting.
Sure, I withdraw the motion and we can send the recommendations over.
Yeah. Are there any objections to withdrawing of the motion for this time? Okay, there being none, we'll bring up the motion after review from the department and comments from the department. At this time, we'll move on to, Committee Chair Stossel, you have any other comments before we move on?
I don't. Thank you, Chair Sampson.
Okay, thank you very much. Committee Chair Judge Crozier, thank you. As Chair of the Minimum Standards Review Committee, I'd like to provide you can go ahead and just read your report. I'm sorry.
Good afternoon. As chair of the Minimum Standards Review Committee, I would like to provide a brief update on our initial work and outline our path forward. The committee is charged with evaluating the minimum standards and proposing amendments that ensure the minimum standards reflect best medical and mental health practices and accurately represent the current state of operations in correctional facilities. Since the formation of the committee, we've held a series of focused and productive meetings aimed at grounding our work in the board's mission and the realities of New York City's correctional system. Our early efforts have centered on reviewing the history and the intent of the minimum standards, identifying areas in need of modernization or clarification, such as the sick call provisions, and establishing a framework for a comprehensive, inclusive review process. The committee will conduct its work in phases, focusing first on priority areas such as restrictive housing and classification. We will prioritize transparency and public engagement, including opportunities for comment and feedback throughout the process. Our goal is to develop thoughtful, forward-looking recommendations that preserve the board's core oversight responsibilities while responding to the evolving needs of the city's jails and those in custody. I wish to thank the committee members, board staff, and all who have contributed to our early work, and we look forward to continuing this important effort with diligence, integrity, and a shared commitment to meaningful oversight and reform.
Well, thank you very much, Committee Chair Corsair. Any questions? Yes, Board Member Cohen.
I appreciate the need or for to look at the standards and to relook at the standards. They were developed a long time ago. I think they're pretty good. And not clear to me that I mean, I think amendments really sort of described more the process that the board should involve than a rewrite. But I want to say again that have this board review solitary confinement with a mayor who blocks the city council rule on solitary confinement and who blocks our rule on solitary confinement is not a worthwhile effort at this time. And if this mayor is reelected, that'll be a different that story will be won't be different, but it will be very problematic. If there is a new mayor elected, perhaps we'll be able to have some discussion about a reasonable approach to solitary confinement and restrictive housing. But this time we can't.
Any other questions for the committee? Okay. DOC variance requests. I'd like to now turn it over to DOC to present their overcrowding variance renewal requests regarding OBCC, EMTC, and West Facility Annex, followed by public comment on the variance renewal request and a board vote. But before you begin, I'd like to address the previous mail variance. And I'd ask that this board consider an emergency meeting within the next 2 weeks, highlighting the concern of the department in their request of a mail variance. That being said, if you seek to submit your variance again, that any special considerations presented by this board be included in that variance request so that we will just have one vote on the matter at the time during the emergency meeting. If there's any questions to that, please let me know. Thank you. Could you turn the mic up a little? Thank you.
Good afternoon, members of the board. My name is Fritz Frage, Senior Deputy Commissioner. I appreciate the opportunity to speak with you today as the department seeks a fourth-month renewal of the variance granted at May 13th, 2025 public meeting. This request pertains to the Board of Corrections minimum standards related to overcrowding, specifically 1-04C2, 1-04C3, 1-04C5I. Since our initial variance request, the department census has continued to rise. We are now housing more than 7,600 individuals, representing a notable increase of approximately 15.37% over recent weeks. Our current population forecast projected continued growth throughout the summer. As the board is aware, the New York State Department of Corrections and Community Supervision, DOCCS, was until recently unable to accept state-ready individuals for local correctional facilities. This temporary disruption significantly impacted our ability to manage population flow. Since May 5th, approximately 260 individuals have been transferred to state custody at a pace of about 30 per week. However, during that same time period, the number of individuals newly designated for transfer has grown by about 35 per week. As a result, our total in-custody population has increased by more than 2%, roughly 160 individuals between May 5th and June 24th. At this rate, the department anticipates retaining an inflated number of state-ready individuals well into the summer. As the board knows, the department has no control over who enters our custody or the length of their stay, but it is our responsibility to ensure anyone who comes into our custody has a bed and services. The rise in census, compounded by the delayed transfer to DOCCS and continued staffing challenges, has created complex and urgent operational issues. While we have made important critical gains in increasing available bed space, the need for flexibility in our housing options remains critical, especially in these 3 facilities. To address these challenges, has swiftly opened portions of the 800-bed tower at RMSC, referred to as Resh Annex, to be utilized to house men in custody with all requisite programs and services. We must acknowledge the amazing staff who work tirelessly to bring these housing areas online as quickly as possible and to ensure access to services to all our PICs. In addition, we have prioritized minimizing disruption or delays and services to the female population during this unprecedented situation. Leadership continues to engage directly with both staff and individuals in custody to ensure that communication is clear, grievances are addressed, and services are offered. These are unprecedented times for the department, but our staff, especially the corrections officers that work on post in the facilities, have continued to rise to the occasion with professionalism and resilience. We are deeply grateful to their ongoing dedication and hard work. Maintaining safety, stability, and well-being of all persons in custody remains our highest priority. In light of continued operational pressures, the department requests a 4-month renewal of the existing variance for OBCC, EMTC, and West facility. We remain committed to keeping the board informed and working collaboratively as we navigate these challenges. Thank you, and I welcome any questions.
Okay, thank you. Do the board members have questions for the department? Dr. Cohen.
You're asking for a continuing variance?
Yes, sir.
Do you have a plan to resolve the continuing variance or how will that require? Do you have a plan for?
Hold on one second, Dr. Cohen, take the pen off the mic, or I think that might be it.
Oh, sorry. Do you have our rules for a continuing variance?
Hold on.
require-
Second, some static, some.
Testing 1, 2, 3, 4. Is that better?
You're good.
Excuse me. The board requirements for allowing a continuing variance, which you're asking for, require that you have the Department of Correction has a plan for not needing the variance in the future. Do you have a plan for resolving this issue so you will not come back to the board in 4 months to ask for the same variance again as you did before?
Thank you for your question, Doctor, and congratulations on your resignation and retirement.
Just for clarification, though, excuse me, it is a limited variance request, not a continuing variance.
It's in a limited variance, but I can't answer that question as do we have a plan? As I said, congratulations on your resignation and your retirement from the board.
Thank you very much.
We appreciate your service. I'm sure the community advocates would appreciate your service. First, let me advise you that the request is not made just out of the fluke of anywhere. The total variance affords us about 234 beds. Right now, we only have 150 left. So if we don't get the variance, we'd have 100 people without beds. So that's the first thing I have to let you advise you right now. The variance right now, as we have it, allowed us to gain 234 bed. The 500 bed annex that we have right now only has approximately 150 left. So that would mean 130 people don't have beds to stay in it if we did not get that variance. So let me just make that clear that the request is not made in jest. It's made because there is no other option for us to get past this. Second, I articulate the fact that the issue that happened here has nothing to do with DOC and how we're doing our jobs. We've got over 1,000 PICs that we would not normally have at the facility. So until the state navigates through their dilemma and corrects those behaviors, we can't do anything about it because we will continue to increase and grow. So once that happens, then we can adjust and see where we could be at to actually withdraw from applying for a temporary variance. It's not a permanent variance.
I know it was permanent. I knew it was not permanent. I thought it was continuing, but you're saying it's temporary.
That being said, I'm sure everybody in the room can understand the situation that we're in. Everything in DOC is not at our request. We don't decide who we get. In fact, we can't say no. We don't decide who comes to our facility. We have no choice but to take them and do our jobs properly and provide them housing and safe and secure environment to reside and live in as they pay their debt to society.
Yeah. Just to follow up on the public advocates' direct in discussion of this problem. And I think the point that I made at the previous meeting, the city is not obligated. Is the city obligated to take these state prisoners? Isn't it a political decision on the part of the city?
No.
We become a state sentence while we in.
The answer is no, it is not a political decision. It is a decision, again, for probably the 4th month in a row. It is a decision made by the courts of the state and judges. When someone is convicted, they are remanded to our custody to serve out their city sentence. That is an order by a judge, a judge who is either elected or appointed. And we are essentially the recipients of that individual pursuant to that securing order. And what we are experiencing now, as the senior deputy commissioner and the public advocate rightly articulated, what we're experiencing now is the situation where the state is only now starting to take, but hadn't since February at a really robust rate, their remanded individuals who are now sentenced up to their state facilities. There is not discretion related to that process. This is not something that we could even negotiate with on that. We are told they come to our custody.
So I understand that you have to take the cases mandated to you by judges for city sentence. I've never questioned that. But the state has to take these people and they should take them. And if they can't fit them in their current bed capacity, they should release people from their bed capacity. This is not a problem that should result in a dangerous situation in the New York City jails because the state is not taking its responsibility.
Well, I agree with you up until that the state should release them. I mean, but also whether they do or whether they do not, that is a decision that is made outside the scope of the Department of Corrections purview. So again, whatever happens above us, when I say above us at the state level or at the court level, that's independent of our capabilities of what we're allowed to have discretion on and any decision making.
But I really appreciate your clarifying it. You
Last
cannot,
follow-up,
just one more, you cannot say, we don't want to, we will only hold so many state readies. Beyond that, we will transfer them to you.
I'm sorry, I don't think I understood that question, Dr. Cohen. I'm sorry.
You're overcrowded because your state ready population is not moving as fast as it should. Are you required to keep those patients, those people in custody? Why not discharge them to the state and let them deal with the problem? Because it creates a difficult situation for your staff, and puts people at risk.
But the discharges are what's at the discretion of the state. Right. There's a step in the process here that I don't think, we're maybe miscommunicating on, you and myself and the board. There's not a level of discretion or a mechanism by which we can just say, sorry, we're not taking you. This is, again, court-ordered remand. The process historically before this February 2025 situation was that the state would say, okay, we're taking the state-ready individuals to the facilities upstate to serve out their sentences. That is still the legal process. The actual administrative and practical process now is that because of the strike, they've not been able to do that. So therefore, our census has increased by 1,000 people pretty much since February to now. They are starting to, I don't want to use the robustly, but they are starting with greater numbers, taking state individuals back. That's why we're hopeful that by the time this limited variance is expired, that we won't have this crisis, or it'll be substantially mitigated. But that's our situation right now.
I hope that's the case, but you're describing the same situation that the Department of Correction is facing with its population.
Excuse me. We're going to move on to the next board.
Okay, I have a quick question. Is the state and the city having a dialogue as to timeframes to accept the state ready?
We've been having, I think since March, at least of this year, regular weekly meetings, the city agencies, and also they're meeting and have been meeting more frequently with the state docs and city government. So state government. So yes, this has been an ongoing process, and I think it's led to what we're seeing now.
So are there any time frames, not to be held on too stringently, but, some kind of time frame?
I'm sorry, Board Member Pitts, I didn't mean to interrupt, but no, there is no specific time frame on it, though we have given them an idea of the numbers that we'd have to have moved to the state to start to see a net decline based on what we normally have on intake for, pretrial detainees, and then the number. So they're trying to get to those numbers so that we see a net decline in the census on a weekly and monthly basis, rather than what is now kind of almost stabilizing, but we're not quite there yet.
Thank you.
Thank you.
Any other questions on the overcrowding variance? Renewal request from board members? Yes, Board Member Garcia.
The limited variance that was granted on May 13 included 4 conditions upon which the variances were granted. Your request at this time for, the renewal of the limited variance doesn't make any reference to those conditions. Is there any problem with respect to continuing those conditions?
No, I don't think, and good afternoon, board. I don't think we have any issues with continuation of those conditions. I think we've been, doing timely submission of those reports on the 10th of each month as requested.
All right, thank you.
I'd like to add that as we're here today discussing this, the role of everyone here is really in the best interest of the persons in custody to make sure they're safe, including Department of Corrections. That is utmost our main goal, to make sure they have safe and sound housing. So this request that we have here, as I said before, is pretty much is not even a question of whether it should happen or not. There is no other option outside of not giving other people beds. But we just want to make sure that as we sit here, we have these conversations and dialogues. Sometimes the conversations become a little one-sided in a sense, where comments and statements are made without the opportunity of seeing what we do and how we do it. So as we've said before, we'd like to make sure that we can invite you over. Like, for instance, there was a thing about the restraints and the problems. But I would encourage you to come see the reasons why some individuals are in restraints and the record to why they got to that point, as opposed to just saying that they're maybe barbaric in nature or things of that nature. They don't have freedom. But, you know, if you're an employee in a PIC facing post and somebody puts feces in a plastic bag and urine and then throws it against the wall and it splashes all over you, that would be problematic. And that's a biohazard for our employees. So some of these instances are real. I just want to make sure that we're aware that I don't want to make everybody here grotesque in what I'm saying here, but this is the real life of what it is being an officer inside of some of these facilities. Granted, we have a lot of people that just here do their times, go on with their lives. But we also have a lot of nefarious characters that, you know, as you commented in reference to SMU, where when they're in general population, they put all the other PICs at risk that may or may not just want to do their time peacefully. And we try and get them in the same areas to help manage them better. These are management tools, not punitive to hurt people. It's really to keep people safe. And I just want to ensure that if you have these questions, we would love the opportunity to show you the reasons prior to making comments that are inflammatory. Thank you.
So I think just in summation, just to underscore, I think we, you know, for the better part of the last couple of months have been managing a situation that we inherited to the best of our ability. We don't want to deal with this as well, but this is the hand that's been dealt with us. We have had constant engagement with the state to figure out, as the GC mentioned, how to move this as expeditiously as we would like to. Again, they kept honest with their time frame of when they were going to resume intake, which was the 5th, and kind of the process remains ongoing. I think you've heard from the public advocate today. I think you also received a copy of a letter from Council Members Nurse and Councilmember Brewer, who also recently toured the jail, specifically Resch Annex, to see how the agency was handling this situation. And I appreciate their leadership and their letter to the state to figure out how we move this along as quick as possible so we can get these state readies to the state facilities. But I think to echo what the SDC mentioned, that we're trying to deal with this to the best of our ability. We remain optimistic that hopefully at the end of this 4-month variance that, you know, we'll have a substantial decrease and hopefully kind of have a plateau of the number of state readies who are in our custody. So we ask the board again to, you know, please continue to support us in this endeavor. Right? This is a situation that's, you know, pretty unprecedented and not unique to something of our own doing. And I think we need to continue that partnership to make sure that we continue to manage the situation till all of the state readies are transferred upstate. Thank you for your consideration.
Okay, thank you. We have a question from Board Member Stossel.
Go back a little, but I do take issue with the way it was just characterized by the senior commissioner. You know, I think I did work in the facilities. I've had urine splashed on me. You know, I don't think that it really serves any of us to talk about individuals in custody as quote unquote nefarious characters. I think Rikers is a dangerous place. It's a traumatizing place. It's a terrifying place. And it really brings out the worst in everyone. And many of the individuals who I worked with who had behaved badly were doing so in an effort to get their needs met. And I think that's really important. So I think, you know, as we're talking about how to maintain safety in this environment while also treating people humanely, that needs to be the orientation, that we're trying to prevent aggression and violence by appealing to everyone as a human being and ensuring that their rights are met, you know, in addition to creating order. So that felt important for me to say. Thank you.
Thank you.
I appreciate those comments. If you mischaracterize what I said in reference to nefarious, it's not nefarious personnel. There's always bad apples in every bunch. Whether it's law enforcement, attorneys, judges, there's bad apples. And the bad apples in this much causes a lot of disruption. I'd like to thank Jamoni Williams for his remarks, where he acknowledged, in this case, he's acknowledged the issues on both sides, the concerns that both sides have. I like the fact that he's in supporting our employees and what they go through. Thank you very much for those comments, because we are all here in the same page to assist, support, and provide proper housing for all of the PICs in custody. But just make it be known that we at DOC also support that. And the oversight is also welcome. I wouldn't be here if it wasn't for oversight. So oversight is always welcome. I think it's collaborative. And the job of DOC and BOC is to support each other to help us maintain and manage this current situation we're in, and to help maintain and manage the PICs in custody to make sure they have a safe environment to live at. Thank you.
Thank you. I apologize for the sidebar while you were closing your comments, SDC. At this point now, if there's no other questions from the board to the department on the overcrowding variance renewal, we'll go to public comment.
The first speaker is Dr. Divine Pryor, followed by Damon Gilbert.
Members of the Board of Corrections, members of Department of Corrections, all of the supporters and allies and advocates in the room. It's an honor to have this. I understand I have 3 minutes. I came here already prepared to say one thing, but after hearing the back and forth, I decided to make some other comments, but will support the overall discussion. And I'm going to say something. I know the Department of Corrections is going to probably, not react the way that I think they should, because they probably won't understand what I mean when I say it. But I would reject the overcrowding variance on principle alone. And it would actually be to their advantage, not to their disadvantage. See, this issue about individuals who are under state jurisdiction but actually serving their time in the city jail has been going on. This is decades. I've heard this same hearing more times than I want to count. It's the same back and forth. But what we fail to realize is that there have always been state prisons inside New York City jurisdiction for decades. The prisons are still right now. We have a number of them. And if in fact an individual falls under the jurisdiction of the state, then they should be inside this state's custody. That's the first thing. The second thing is that we should all be aware that it has already become city law that Rikers Island would close in 2027. We now know, based on actions that have been taken or are being taken, that it's very unlikely that that will happen. What does that mean? That means when that time and date comes where the law has already indicated that Rikers should close, which means there are going to be a lot of people out of compliance. Or better put, they will not be following the law. So how will we handle that? So I think that there's a whole different discussion that should be happening. And I'm not understanding why the state is not here, why state lawmakers and policy makers are not here, why Department of Corrections, New York State is not here. See, we continue to operate in these silos. And as such, we have these conversations and that information is not being shared with each other. And so the same conversation that I heard back in 1970, 1980, 1990, 2000, 2010, 2020. So I'm talking 50, 60 years now. And now 2025, we're having the same discussion. That we're all very, go ahead, you can clap if you want. I mean, I retired in 2019, by the way. I was called out of retirement in 2020 due to the George Floyd murder because I had some special skills that right now are in effect. I am the Chief Executive Officer of the People's Police Academy. I am a member of the Commission for Community Reinvestment and the closure of Rikers Island. So I have an opportunity to see this issue from various different perspectives. And what I'm recommending in my closing remarks, I know my time is up, is that we do not meet unless all parties are at the table at the same time. Because I think that this is not demonstrating the extraordinary wealth of intelligence that we have in this room by continuing to operate the way we have. Thank you so much.
Thank you.
Thank you.
Thank you. Next speaker is Damon Gilbert, followed by King Downing Esquire.
Good afternoon. Thank you, Chair Sampson and members of the board for having us here today. My name is Damon Gilbert. I'm an attorney with New York Lawyers for the Public Interest, and I'm here to urge the board to deny the DOC's requests for those 3 variances. The Board of Corrections minimum standards exist to ensure safe, humane, and constitutional conditions for people in custody. These standards, specifically the dormitory cap, the square feet per person requirement, and the sink to person ratio, are not arbitrary. They're the product of decades of experience, public input, and a clear recognition of the dangers that overcrowding poses to both those incarcerated and those who work in these facilities. This board has in the past rejected proposals to permanently relax these protections, which emphasizes their fundamental importance. The variance process is meant to be exceptional and temporary, not a routine mechanism for managing chronic capacity failures. Accordingly, the board is required to apply a high level of scrutiny to any variance requests, demanding convincing evidence that the variance is both necessary and justified. And in the case of renewals, there has to be a good faith effort to comply with the minimum standards and the conditions of any previous variance. Since March, the DOC has repeatedly sought and received variances, citing ongoing delays in state transfers and mental health placements. These are real challenges, but the department now has had several months and multiple variance periods to implement sustainable solutions, such as the use of the 6A early release program. Despite this, almost nothing has changed. The DOC now seeks to continue these overcrowded conditions, and seemingly it seems only 2 people were released through the 6A program since their last variance approval. Thus, granting these variances again would effectively render these temporary exceptions permanent, which undermines the very purpose of the minimum standards and could set a dangerous precedent for future oversight and management. Moreover, the health and safety risks of overcrowding are not theoretical. Overcrowded dorms worsen the already poor hygienic conditions and thin medical services available in Rikers facilities, so an increase in population will directly increase the risk of violence, disease transmission, breathing issues, and serious mental health exacerbation. The board's own findings and the tragic record of deaths and abuse at Rikers make clear that they're not conditions that the city should continue to tolerate or accept. In sum, the DOC has not met the legal threshold for another variance. It has not demonstrated that compliance is impossible despite best efforts, nor that all conditions of the prior variances have been fulfilled. The board should reject these requests and instead direct the department to focus on real, lasting solutions to restore compliance and protect the dignity and safety of all New Yorkers in its custody. Thank you.
Thank you. And I'll just ask that the next name that I call after the first name that I call just sit at the first row so that we can ease people into the podium. So the next speaker is King Downing Esquire, followed by Riley Doyle Evans.
Good afternoon. Thank you for this time to speak. I would just like to add as a quick note, Maybe the clock won't start because this isn't part of my presentation. It's been difficult to hear some of the people, especially from DOC. We have these microphones, all this technology. Maybe everybody in the board members could speak up because I'm hoping that the people who are remote can also hear what's being said. So I am the director of the New York, New Jersey American Friends Service Committee. We are, I wasn't going to say this till the end, but we're abolitionists. I'm going to come out and say it. We do not think that the system as it's set up can take care of people. We're not saying we're against keeping people in protective custody for the community or other purposes, but the way it's working now is not working at all. And I'll just quote Angela Davis. She says, the reason why we remind ourselves of that we're abolitionists is so that we don't settle for reform. And that's what we're trying to do here. We just keep reinventing the wheel. Of other priors talking about something that has been going on for decades. And it's taken somebody who has put in a decade and a half to leave, and we still are not making the progress. I'm not going to add anything to the argument because I support Dr. Cohen, Public Advocate Williams, co-chair who's online. If you would repeat your last name, I couldn't hear it. Dr. Pryor. Every speaker is reporting the same information. And the only way I figured I would do another take on it is to try to liven things up. It's been a long afternoon. I want to quote somebody who is not normally associated with justice, and that's Miles Davis. Miles Davis says, it's not the notes you play, it's the notes you don't play. And what we've been hearing now are certain notes from the department, but we're not hearing the notes that aren't being played. With this variance and this increase, what's going to be done with the mental health issues that we heard complaints about? What's going to be done with the sick calls? What's going to be done about the violence? We haven't heard any of that in anything that's been presented here. So that's our question. What is going to be done about these issues before moving ahead? Here's the other thing. The administration has talked about being very aggressive in dealing with crime and dealing with the community. I haven't heard anything about aggression in dealing with a state institution with lots of resources that is not going to find a place to put people that they are forcing on us here in the city. Where's the aggression to use elder parole and the other bills we've been passing? They don't have to wait for the legislature to do that, to let people out. They could do that now, just like they did during COVID. So I would like to hear where the battle has been. If you don't solve this problem, we're going to take you into court because we're not going to take any more people. We're getting caught with the deaths, the destruction, and all of that. So I want to see the fight and pushback there. And I agree with Brother Pryor. If everybody's not at the table, then we're not going to get anything done. Thank you.
Thank you.
Thank you. Riley Doyle Evans, followed by Christopher Boyle.
Good afternoon. Tough act to follow, thank you. And I won't try to even come close to matching the important words that were just shared, but I will just try to build on what's already been said. My name is Riley Doyle Evans. I work at the Prisoners' Rights Project of the Legal Aid Society. Just want to touch quickly on something that happened during the course of this meeting, acknowledging that DOC may lack some authority in terms of addressing the crowding problems due to docs issues, due to commitments at the city level through the courts. What happened today really betrays a disturbing lack of urgency in dealing with the core problem that is leading people into the jails. The BOC presents some very straightforward and clearly effectuated recommendations on improving the use of 6A, and the response is to kick the can down the road on the procedural basis. Well, we didn't get a chance to look at it before the meeting. You don't need to. You can take the board's recommendations, consider them, and implement them to get people out of custody. The department can't have it both ways. They can't say, give us more variances, give us more authority, let us lock people down because we have this population problem. But as soon as you offer us a potential solution to address that problem, well, slow down. Where's the urgency? And it's not limited to that. I think while the department staff may have limited authority, they're part of the city. The city can take action urgently to stem the tide of people coming to the jails, and they must. How many more people have to die? Beyond that, DOC can work more urgently with docs to deploy Correction Law 95, which was used during the COVID-19 crisis, to certify people's state time in city jails and get people who are parole eligible, who are eligible for conditional release, out of the jails. Finally, just to emphasize that, to the extent that the board feels inclined to grant this continued variance, I would urge you to consider additional conditions that could be placed on granting that variance that would inspire DOC to actually take steps to address some of the fundamental problems rather than leaning on this challenge as an excuse to continue business as usual. DOC has come here over and over again with this variance, but hasn't presented a plan both to obviate the need for the variance, but also to address the underlying concerns that put people's safety at risk in crowded dorms, as my colleague mentioned earlier. So to the extent that basic security failures due to failures to supervise, to set up mechanisms at a structural level to ensure that staff are doing their jobs, that supervisors are rounding, all of these things must happen if we are going to allow them to open crowded dorms and maintain crowded dorms. And they haven't happened. They've been the subject of litigation for years and continue to be a problem. So again, just to close, I think using population as an excuse to not fix long-standing dysfunction, those excuses are wearing thin. And one place where DOC is asking to add beds is EMTC, which is a jail that has notoriously failed to keep people safe, and where Benjamin Kelly recently died in custody. Thank you.
Thank you.
Thank you. Christopher Boyle, followed by Sarita Daftery.
Good afternoon, all. My name is Christopher Boyle. I am the Director of Data Research and Policy at New York County Defender Services. I've been sitting here all afternoon. I could barely contain myself. I have been listening to the Department of Corrections here talk about what their legal obligation is. I'm going to read you from the CPL, that's the Criminal Procedure Law 43020. It says indeterminate and determinate sentences. For those who don't know, that's all upstate sentences. In the case of an indeterminate or determinate sentence of imprisonment, commitment must. You know how it says must? It doesn't say should. It doesn't say due to overcrowding. It doesn't say when there's a handshake from the state, please hold on to people. It says must be to the custody of the State Department of Corrections and Community Supervision as provided in Subdivision 1, Section 720 of the Penal Law. The order of commitment must direct that the defendant be delivered to an institution designated by the Commissioner or Corrections and Community Supervision. State Department of Corrections can declare that city Department of Corrections is now a state facility so they can calculate jail time. We in our office have a client that we've been fighting since March that would have been out on parole, but is stuck because State Department of Corrections states on the record, under oath, they don't care about parole eligibility dates. They do not care about parole eligibility dates. They only care about conditional release dates. So you understand on a 1.5 to 3 sentence, when that client would get out at the 1.5, 3 mark, at the 1.5 year mark, because he's supposed to have a parole hearing months before that 1.5 has to happen, they're saying he stays in for 2 years. So that means he sits on Rikers Island as another person taking up another space on Rikers Island because they declare that they are not considering parole eligibility dates. And if you give them that variance right now, that's what's going to continue to happen. Okay, because we were sitting here in May and I said to myself, they're going to come here in July and they're going to ask the same exact variance because there is no plan. They have fired 2,000 or more people upstate. There is, as far as I can tell, no class that's been hired. They have lowered the eligibility down to 18-year-old kids, and they still don't have a class that's ready to be in place to take upstate people. So what do you have? You have a perfect storm of them coming in here right now and saying, we don't have any control over this. They do have control over this. They could turn around and say, our statute mandates you have to take these people. They could take State Department of Corrections to court. They can be in here with the State Department of Corrections and try to solve this problem. But State Department of Corrections, under the Attorney General's office, has made a decision and said, sorry, PE doesn't matter to us. Parole eligibility doesn't matter to us. Just conditional release dates matter to us. And it's continued to be a problem. And forget OMH. We have over 200 people who are not going to state hospitals that are sitting on Rikers Island right now deteriorating, and they're holding on to them even longer. So now we have a perfect storm of State Department of Corrections people, as well as people who are mentally ill sitting on Rikers Island, sitting in these places, and nobody's doing anything about it. And I'll mark my words, 4 months from now, they're going to come back here and say, don't worry, we're going to ask for another variance. And one more thing I have to add. I'm sorry, I'm taking more time. One more thing to add here. They don't have the numbers right. Okay, they have not gotten a crest over the wave. So they were in here in May and they said there were 1,000 people that were waiting on Rikers Island, waiting to be moved to the department, to the state corrections. They come in here, oh, it's another 1,000. How did that happen? Because the amount of people that are being sentenced every week is a 2-to-1 for everybody that they're moving. So every one person that they're moving, that State Department of Corrections is able to move, they are 2 more people are replacing them. You will never get to that 1,000. And mark my words, 3 months from now, 4 months from now, there'll be 2,000 people on Rikers Island because State Department of Corrections has no plan. They will never get to that number that they need. So understand that this is just not going to go away. Okay? Do not give them this variance. Don't give them this out because the problem will not be solved if you do that. If you don't give them an out, they will have to solve the problem. You must order them to do things here, like give you a list of names. When is PE Day coming up? How many people on the island? How many people are being sentenced? Don't allow them to come in here and say, well, yeah, around 30 people are being sentenced, around 28 people are being moved. Don't allow them to do that.
Excuse me, Mr. Doyle. Mr. Doyle? Just a question. Is there a governor's executive order or anything that prevents this this action?
As far as I know, they have not cited that in any of the litigation that we've been involved in. We have been litigating the client that I told you about, which was the parole client that needs to be moved. We're now going to be taking a writ on him this week to have him moved. And I'm assuming that the State Department of Corrections will continue to say the same thing. They're just not considering PE date. They're not considering any of these things. Upstate is also having a problem which you may not be aware of. This is not a city problem. This is a statewide problem. Rikers Island just happens to be a bigger facility than most of the state. So when they say that they're moving people, they sometimes clump in that they're moving people, like we got information that they moved about 275 people. But when you look at the numbers, it was 275 people for the entire state, not just Rikers Island. And what happens is you have these small counties upstate that do not have the ability to handle as many people as Rikers Island can handle right now, even though they're asking for the variance. And they're going to start to move more people upstate. So our share of the people that are being moved are going to get less, not more, because upstate's going to fill up quicker. They're not doing anything about it. At some point, they have to do something. They have to declare an emergency. They have to do the calculation for jail time at Rikers, which they refuse to do because they're holding. The longer we go, you're going to have a bunch of these clients who are 1.5 to 3 and 2 to 4. They're going to build up, and those clients aren't going to get out because they can't have their jail time calculated. They can't have their parole hearings. That will not happen. And so you're going to end up with more people on the island that could be off because State Department of Corrections are just saying, we're not giving parole hearings because they're not in state custody. Well, why aren't they in state custody? There is a statute that allows them to declare a portion of Rikers Island or the Queensboro facility. They can declare that a state facility and calculate that jail time. They already do virtual parole hearings. There's no reason why they can't do it. You cannot allow them to get away with this. They have to force the state. If they can't hold it, then they'll force the state to do it.
Thank you. We have maybe one other question from Chair Stossel, but we will take that under advisement and perhaps set up a meeting with the state on this matter. Board Member Stossel.
Thank you. Yeah, this is very interesting, and I'm out of my depth. I think first, I do think it would be helpful to be able to sort of arrange a time offline to understand more about what it is that you're describing. I think certainly, given sort of the limits of what we've been speaking with DOC about so far about early release, this parole eligibility question seems like a really important one. And I just was hoping we could make sure that DOC has a chance to respond to some of what you've said, because I think it's really important. And I'd just like to hear what they have to say about it.
Yes, I don't know if it's appropriate for a response unless they choose to, but if they choose to, that's fine. But thank you so much, Mr. Good.
I think we'd be happy to engage offline, off of this. I mean, there are points that were raised that are more complicated than what Mr. Boyle kind of seemingly presented, independent of his client's specific situation. But we could certainly talk to the board about this issue of parole and what's being able to be calculated on Rikers.
Okay, we'll set a meeting for board members of interest
Yeah, that's
for that
fine.
discussion.
Thank you.
Thank you.
Next, we have Sarita Daftery, followed by Natalie Fiorenzo.
Thank you. Good afternoon, board members. My name is Sarita Daftery. I'm co-director of Freedom Agenda. Our members are people who are incarcerated, have been incarcerated, whose loved ones are incarcerated in New York City jails. As you've heard loud and clear from so many people today, the board must reject this variance. The department will present that they are doing everything they can, and as you have heard, they are not. They clearly are not. And what they are saying seems to indicate that they are willing to let Rikers fill up and let more people suffer. As you heard, the people who called in and gave through the hotline and spoke to the board, let more people suffer and more people die, as Benjamin Kelly and James Maldonado did, less than 2 hours apart. The board cannot allow that. I want to focus on one tool that DOC is not using, which is the 6A program. This board clearly recognized in May that DOC was not using the 6A program to its fullest potential and rejected the DOC's variance request. In the same meeting, DOC described an annex of RMSC that has been adapted to house 155 men and said regarding this annex, we specifically chose city sentenced people, low classification. So I ask, why would these 155 people not be candidates for release under the 6A program? And the board should ask them that. If the situation DOC is facing is truly extraordinary, then they should take extraordinary action and substantially expand the use of 6A. 5 years ago, the Department of Correction and the Mayor's Office of Criminal Justice took swift action to reduce the jail population in the face of COVID-19. That is what's needed now, not continual variances that lead to further deteriorating conditions for both people in custody and staff. In March 2020, the 6A program was used to facilitate the release of 300 people in less than a month. And less than 1% of those released were later arrested on a violent felony charge, and only 5% for any felony. DOC's recent variance request noted that they have released 36 people so far this year under the 6A program. When they submitted their variance request in May, it said they had released 34 people. So after the board had a whole discussion about how they should expand that program, they released 2 people in 2 months. That does not sound like doing everything they can. There are no good options for housing over 7,500 people on Rikers Island. Cramming more people into the decrepit housing units at EMTC, OBCC, and West Facility is not acceptable. Housing men at Rosie's is not acceptable, nor is reopening AMKC, given the serious infrastructure deficiencies that led to its closure in July 2023. The city does have one facility that's in good condition, the newly constructed outposted therapeutic housing unit at Bellevue Hospital. DOC can move up to 100 of the most medically vulnerable people in its custody to this unit immediately, but has refused to come up with a reasonable staffing plan that matches the fairly minimal need for uniformed officers in this medical unit. DOC should use all of the tools at their disposal to bring down the jail population, and every other criminal legal system stakeholder should as well, and the board should be urging them to do that as well. Again, I urge the board to reject this variance. And before time is up completely, I do want to thank Dr. Cohen for your many, many years of incredible service and efforts to make sure that people's lives in custody are valued. Thank you.
Thank you. Thank you, Sarita.
Thank you. Natalie Fiorenzo, followed by Chaplain Dr. Victoria A. Phillips.
Hi, everyone. Good afternoon. My name is Natalie Fiorenzo. I'm a senior corrections specialist at New York County Defenders. And I want to start by clarifying that even though my supervisor, Chris Boyle, talked about one client that they're in the courts fighting for him to get out now 6 months past his parole eligibility date, he is not our only client at our office who is having this issue. We are now looking at clients whose parole eligibility date is in 2026 because it can take about 6 months for the state to prepare for a parole hearing. There are a lot of documents they have to acquire. And this is not an isolated issue for just one client, not to mention we are one of 10 or a dozen public defense offices in this city. And let's not consider the rest of the state. I'm not truly sure why this variance was passed again 2 months ago. The point of the minimum standards that you all created is to keep people safe and give them human decency. DOC is requesting these variances to accommodate a huge problem that they have, which is the influx of over 1,000 extra people on Rikers Island. But this is a man-made problem due to the illegal strikes of state corrections officers. Why are we accommodating the problem rather than fixing the problem? Why is DOC accepting the state's issue rather than pushing them to fix it, pushing the governor to fix it, pushing judges to fix it? They tell us, they've been telling us for months, they do not have the power to decide who gets put into their custody and when they are released. We are not objecting to that fact. We know that. We know that judges are the people that remand PIC into their custody. But we also don't have the power to take people in and out of custody. For that reason, we push and we push and we advocate tirelessly with judges, with district attorneys, now with the governor's office, with state DOC to decarcerate now, not yesterday, not tomorrow, now. The problem is there are way too many people. That doesn't mean you fix it by accommodating too many people. You make less people. It's not rocket science. I am urging again for the BOC and DOC to address this problem, not accommodate it. Thank you.
Thank you, Chaplain Dr. Victoria A. Phillips. And then we'll move on to the WebEx commentators. First up would be Diana Eskew.
Can you hear me? Peace and blessings. No, yes. No. Can you hear me now? Okay. Peace and blessings, everyone. I'm Chaplain Dr. Victoria Phillips, and today I'm speaking as an individual, and really as a leader in the Jails Action Coalition, the Beyond Roses campaign, especially. Several BOC meetings ago, DOC actually confirmed that there were about 30 plus individuals that had been given the 6A access this year. And yet the department mentioned it was around 350 individuals that were eligible at that time in that meeting. And so as Sarita just recently mentioned, I'm concerned about why it hasn't been fully utilized, especially when they say it's overcrowding, especially when 2 to 3 floors in the Rosie's building, Rose M. Singer, has been filled up with male population when the building was built for women. I can only imagine what Singer's daughter would think about this right now. So inside the scope of DOC capabilities, I only want to speak about what's their scope, right? Since they always say what's not in their scope. Their scope is to follow all minimum standards. Their scope is to actually utilize 6A. This strike this year with the state DOC should not hinder how DOC follows the law. As it was mentioned before, during COVID, transfers were paused as well, but DOC found a way to decrease the population utilizing 6A immediately. I just want to highlight something that is not really brought up in this meeting. You know, when we talk about overcrowding, as a chaplain and as a mental health professional, I know directly working behind the walls for many years in various capacities how overcrowding impacts detainees as well as uniformed staff. And any other staff that has to go throughout these units. Overcrowding does something to one's psyche. You know, when you think of overcrowding, I've been splashed before while working as a nurse with feces and things, so I know how that feels, and it's not great. But I've never been splashed and put in a situation where I wanted to cause harm or beat someone down or allow them to die or deny them medical access to a specialist or give them their medication or allow them to sit in pain or their urine or their own feces because of something that they did. And I just want to speak on humanity, because as an Army brat, when I think of paramilitary organizations, and DOC prides themselves of being one, I realize that leadership really falls short. And it's disheartening because as a paramilitary organization, when one person is dropping the ball, the platoon is supposed to pick them up, not cover their faults and continue for them to allow to do wrong and break the law and not do what's right. And so I just want to beg each of you, and I never beg, but we've lost 2 lives since the last time I asked you how many people have died in Rikers this year. As the oversight board, we've lost 2 lives in the same day since I asked you that last month. So when you speak of overcrowding, I want you to think of what it really means. What it means is a heartbeat continuing to beat. What it means is having adequate access to medical care. What it means is not being put in a situation where you're causing harm to those who need to depend on the people in position of power and those there trying to do their job. Don't create more trouble and don't create more harm when you can't do what's right. Step up and hold them accountable and hold the state accountable as well. Peace and blessings.
Thank you. We don't have anybody on virtually who had signed up to speak, so that's the end of comments.
Okay, thank you. So we will now have a vote on overcrowding variance renewals. Does any board member move to vote on the variance renewal?
So moved.
Is there a second?
Second.
Now we'll have a open discussion on the floor to debate. Yeah. Dr. Cohen?
Thank you, Chair. I think we've heard some excellent arguments today, which are absolutely convincing that we should not approve these variances. People die, as happened last week. The department has no plan. The state has no plan for resolving this issue. Rikers Island cannot just expand and expand and expand. And fundamentally, jails are bad places and prisons are bad places, and we should not make them bigger and bigger and bigger. We have to make them smaller and smaller and smaller. These variance requests go in the absolute wrong direction, and I urge all members of the board to vote against them. Thanks.
Okay, thank you. I'll ask the department to present your variance, if you can read your variance regarding if there's conditions. After the reading, I would ask a board member to move for any conditions. I know that there was discussion about previous conditions.
Yeah, I do, Chair, I don't know that we have a copy of the variance with us. I mean, as we acknowledged in the opening statements, we're making our application. The variances with the exception, this variance request with the exception of being for a 4-month limited variance, the conditions and the request are the same. I mean, we could probably obtain them and I could read them, but I think we were under the impression that the board had them and,
It's in the board book. We'll find it. And,
thank you, Chair.
Page 51 is, if there's any questions on the variance.
That's the conditions.
The conditions. So we have a motion and a second on the variance. And now I'd ask if anyone will move to add the conditions. I know there was discussion about previous conditions.
Yeah, I would move to include the 4 previous conditions.
Is there a second?
Second.
Could you read the 4 previous conditions, please?
1, the department must make a commitment to maximize the use of the 6A program and review the 6A program in collaboration with the board's ad hoc 6A review committee to come up with recommendations on how to maximize the 6A program releases. 2, the department must ask for a variance for all housing areas where the overcrowding standard or any other standard is being or is planned to be violated before action is taken and the board considers this request. 3, DOC will report monthly by the 10th of the next month all admissions and discharges from restrictive housing units, including West Facility, SMU, RESH, NIC. The report will include reasons for admission to restrictive housing, the reason for discharge, and the discharge housing location. 4, the department will report monthly by the 10th of each month current criteria used by the commissioner to identify sentenced persons in custody eligible for discharge, all admissions and discharges of sentenced persons, number of sentenced persons discharged by the commissioner under authority of the 6A program and their discharge housing plan, number of sentenced persons in custody who meet the department's 6A discharge criteria but remain incarcerated, episodes of violence, i.e. fights, slashing, stabbings, assaults on officers, and use of force, identifying which of these events occurred in overcrowded housing areas in OBCC, West Facility, and all other overcrowded areas, housing populations higher than those allowed by BOC minimum standards. Number of persons in custody who have been incarcerated for more than 1 year, 2 years, and 3 years with the names and the NYSID number. And finally, breakdown of census and staffing plans of each facility covered by the variance.
Could we add to?
Yes, would you like to add a condition, Board Member Pitts?
Okay. I'd like to see added that the Department of Corrections, within the scope of their authority and legally, if we are to grant a variance, that they must put pressure on the state in any manner that is available to them to do so. And that they inform us when we receive reports, what that pressure is, be it legal or otherwise.
May I comment?
Yes, please.
I think with the exception of, I appreciate this, the notion that you're trying to get forward. I think unfortunately, pressure is a very amorphous and ambiguous term. I do know what you're getting at, Board Member Pitts.
What's the word? What's the word I want?
Efforts. I think efforts to
Okay,
work to the
efforts,
state, yeah.
real substitute.
So we'll continue, as I've represented, that we have ongoing dialogue within the city government and then also up to docs. We'll put a record in as to what efforts we're engaging in as far as the Department of Correction goes, along with other city partners, and we'll report to the board on that. Just on the idea of pressure is that's a tough concept too. I know what you're getting at, but it's a tough concept to write.
Right, thank you.
Just to be clear, the efforts or pressure that we're talking about, are we talking about to the state Board of Parole or state Department of Corrections?
State Department, it could be that also.
So
But State Department of Corrections. They should receive these people. They should take them.
I know
They
that.
should figure it out.
Okay, so I know there was questions on state parole when the gentleman spoke. And also, so now are we saying state parole, state correction, or
We can
state authorities?
state authority.
I think we could commit to reporting on efforts holistically within the system to address this situation. Whatever efforts we're undertaking, again,
Okay.
with city partners or otherwise.
And, okay, is that friendly as a condition?
Yes.
Okay, so we'll add that to the commission. Any board member Stasso, I know you're remote, but I want to make sure you're engaged on it.
Yeah, I don't have any conditions to add. Thank you.
Okay. All right, so that being said, we'll take a vote on the variance with conditions as stated. And there are 5 conditions. All in favor of the variance with conditions on overcrowding?
Aye.
I'll do a roll call vote. Jude? Board Member Pitts?
Aye.
Board Member Cohen?
I abstain. Because we should not approve the variances.
Okay, Judge Kusier?
Aye.
Board Member Stasso?
I'm going to abstain from this one also. I have some reservations about this. Thanks.
Okay, and I vote aye. So the variance carries 4-2. And the variance.
In a variance, you just have 4 votes? I don't think so.
Yes. Yeah. The vote doesn't carry. My error, I thought it was a majority, but it is minimum of 5. It is not a simple majority. With that being said, I've asked our executive director to set up a meeting with the State Department of Parole to assist in probably getting to the bottom of some of this. I know the chair very well, so I think a meeting with his team and our team can maybe help the department deal with some of the overcrowding issues in light that the variance has failed. We'll go now to DOC updates. We will now hear updates from the department. DOC response to BOC assessment and recommendations regarding lock-in and lockout procedures.
Good afternoon again. Good afternoon, members of the board. My name is Fritz Frage, and I'm the Senior Deputy Commissioner. I appreciate the opportunity to provide you the department's response to the board's reported titled Assessment of New York City Department of Corrections Lock-in and Lockout Procedures. As the board is aware, the issue raised during the board's October public meeting, which was referred to at the time as deadlocking, is currently under investigation by the New York City Department of Investigations, DOI. First, the term deadlock is not used in the department's policy. It is not a term recognized operationally by our staff. For this reason, the department suggested that terminology in the report be revised to unauthorized individualized lock-in, which more accurately reflects the conduct at issue. As we discuss this matter, it is important to clearly distinguish between unauthorized lock-ins and authorized involuntary lock-ins. Unauthorized lock-ins are not permitted under DOC policy and are the subject of the allegations raised during the board's October public meeting and the current report. Authorized involuntary lock-ins are permitted under the departmental policy under specific justified circumstances. These include credible threats of violence against staff or others in custody, or incidents that present a serious and ongoing threat to the safety and orderly operations of the facility. Since these allegations were raised, we have taken proactive steps to reinforce our policies and expectations. Department leadership has communicated both in writing and through facility briefings that any unauthorized lock-ins will be the subject to investigation. Additionally, a department-wide teletype was issued on October 29th, reiterating that strict compliance with directives 4009R-C is mandatory. The department takes this matter very seriously and remains committed to transparency, accountability, and ensure the safety of both individuals in our custody and our staff. Thank you very much for this opportunity to speak today. I welcome any questions from the board.
Any questions? Dr. Cohen?
I mean, we use the term because you use the term. I mean, you wrote it down for maybe you stopped writing it down now. But have you ever tracked who's doing it? What officers are making these lock-ins that they should not have made?
That's under investigation, but
Yeah, as the STC stated in this statement, so when this issue was first brought up, we referred the matter out to DOI. As we said, we could very limited comment on any aspect of this because it is under investigation. We're actively exchanging, I mean, even as of yesterday, documentary and video evidence with DOI. So we have to stand on that for the time being.
I have a question. Thank you. I was just curious, what measures is the department using to ensure that uniformed staff are well informed, for lack of a better word, of that deadlocking is not acceptable?
First of all, as I just stated, the term is not being used, and we advise all personnel of that standard. We've also reissued the directive that prohibits that type of behavior and what is prohibited. We've had discussions, and there will be discipline if those measures are not met to that standard. But there's constant review, and everything has to be documented.
Thank you.
Okay, any other questions on lock-in and lockout procedures from the department? If not, we'll go on to follow-up items, status update regarding restricted housing unit.
Good afternoon, members of the board. My name is Francis Torres, and I serve as the first Deputy Commissioner. I am here to provide a status update regarding the provision of mandated services at RESH, the RESH Annex, and the Special Management Unit. To reiterate, the department does not recognize or categorize SMU as a restrictive housing program. It is a special management program for those who have demonstrated a high propensity of violence and disruption. I would like to clarify that the RESH Annex is not restrictive housing. Men housed at the RESH Annex are general population. They are in general population units. The department continues to ensure that all individuals housed in the SMU at OBCC receive their mandated services. And we remain committed to maintaining that standard. Mandated services are also consistently delivered in RESH despite recent operational adjustments related to staffing to support RESH Annex. The men housed in the RESH Annex continue to receive programs and social services, recreation, commissary, barbershop access, religious services, and law library sessions as scheduled. As shared last month, the new recreation yard, which will be dedicated exclusively for use by the men housed at RESH Annex, is on track to completion by August. We acknowledge there are some initial delays in service delivery to the women housed at Rosem Singer following the opening of the RESH Annex. However, the department continues to adjust and monitor closely the operations, and we make adjustments as needed. All mandated services for women, including recreation, remain in place and are being delivered in accordance to the board's minimum standards. We are aware of the challenges that this situation presented for everyone. We continue to work through them. Ensuring access to mandated services for all persons in custody is a top priority for the department. We recognize the importance of maintaining consistent and equitable access across our entire population, and will continue to keep the board updated as we move forward. Thank you.
Thank you. Dr. Cohen?
Deputy Commissioner, if the units that you were describing, if we're describing and calling restrictive units, the reason we're calling them restrictive units is because they do not get 14 hours, the men and women in them do not get 14 hours a day, which is required by the board standards. So why are you saying that they're normal general population?
I will let counsel answer that.
But that's what you said.
I know what I said. I read it, but I will let counsel answer that.
So we've discussed this, going back to when the special management unit started. We confer with the federal monitor and our consultants on this issue, and we've talked about the need to have something other than RESH, which is the enhanced restrictive housing, which has a number of restrictions that SMU does not. There is an element, as you said, with the time out of cell, which is one of the board standards that's under suspension, but that we don't generally follow or restrict in other areas of the island, anywhere else. And in this circumstance, while we do have a due process procedure for it, because of all of the other considerations regarding no other restrictions to the people that are housed there, we've consistently in our conversations with the board and elsewhere that called it a management unit for that reason. I do appreciate your distinction on that, but there is a difference between what is our restrictive housing units under our current policy and what special management is.
You can pay Dr. Whatever his name is, as much as you want to give you the answers you want on what's a restrictive housing unit or not, but they're only getting 7 hours. And that's general population does not get 7 hours. This is a restrictive unit, and because or you may or may not be giving programs to them, that does not mean that it's a general housing unit, and these people are not in general population. So it is not useful for us to pretend that things are happening that are not happening. I appreciate you're trying to create a discussion, but we should use words that we've been using for a long time. General population gets 14 hours a day. Restrictive housing gets less. I hope the board will continue to demand that.
Any other questions to the department on SMU? Status update regarding amendments to Directive 3376R.
One moment, Chair, if I may,
Yes.
before I move away from the podium. Dr. Cohen, on behalf of our department, thank you for the many years of service you're giving the board. I sincerely hope that you have a long and healthy life, and we appreciate it, the challenges, the open dialogue, the conversations, and the fights. Thank you.
Thank you very much, Deputy Commissioner. Really, thank you.
James Boyd, Deputy Commissioner, Strategic Operations. Happy to take any specific questions about the revision of the grievance directive, which we are trying to make updates to. I think the last update to our grievance directive was in 2019, I believe, or 2018. So we are trying to make those updates as the grievance process have evolved and how we've evaluated to make sure that it is serving up the population needs and making sure that it's fair, accessible, and responsive to people in custody. So I think once we have a more ripe draft available, we'll be happy to share something with the board for your feedback as well.
Okay, thank you. Any questions? And lastly, for the department, the status update regarding immediate compliance with sick call requirements.
Good afternoon, board. Members of the board, my name is James Saunders. I serve as the Deputy Commissioner of Health Affairs, Compliance and Quality. Since our last public meeting, the department hosted 2 briefings for the board just last week, which included a live demonstration of a prototype of the clinic production dashboard. The platform, which is very much still in progress, will allow all parties to comprehensively track both scheduled and unscheduled clinic visits, ultimately providing a more robust and data-driven way to meet the expectations outlined in the minimum standards. So as of today, we remain in the technical phase, the technical implementation phase, in close coordination with our partners at CHS, and we're still on track to fully launch the dashboard by the end of the year. We will continue to keep the board apprised of our progress. And we appreciate the opportunity to continue to have dialogue both publicly and privately. And I do want to echo the sentiments shared by the SDC and the FDC. Mark Twain once said that it's curious that physical courage should be so common in the world and moral courage so rare. So I just want to thank Dr. Cohen for his moral courage, his zealous representation of the persons in custody over these past 16 years. It has been an honor to work with you. So if there is any questions?
Any questions on sick call dashboard? No. Thank you. Thank you to the department. We'll now go to CHS variance requests. Variance renewal request regarding minimum standard psychotropic medication.
Good afternoon, board. My name is Joseph Otanakar. I'm the chief of the mental health service with CHS. I'm before you this afternoon requesting a renewal of a 6-month renewal of the variation for the standard requiring that patients be seen 14 days for medication reevaluation visits. For the past 19 years, I believe this variance has been granted, and the reason for it, I think, is very important in that it allows us to provide individualized patient care that is based on community standards. As a department, we really strive to go beyond what the community standard is, but seeing patients every 14 days who are in general population, who are assessed as clinically stable, really is outside of what is typical and what is clinically indicated in the best interest of patients. And so we're again asking for this renewal in the interest of patient care and allowing prescriber and patient decisions to be tailored to the needs of individual patients. I'm happy to take some questions.
What's the renewal? Is a 6-month renewal?
We're asking for 6 months today.
Um, Okay, thank you for that. I also, I know I had some issue on this variance, just on the grounds that it's been going on for so many years.
Yeah.
We do have a minimum standards review committee chaired by Judge Cruzier. I recommend that you present something to the committee and to our staff that can make a permanent recommendation change to the standards. That's why the committee exists, so that we can address, I guess, modern day issues.
Yeah, no, I'd be happy to give a presentation to, if helpful, to make that change.
Okay, thank you. Any questions, Dr.
Yeah,
Cohen?
I appreciate you're trying to do this. It's totally ridiculous, every 6 months. And you're practicing standards medicine. That's also, I assume you read it. We've been prescribing it for years. But this is a standard, and we can't change standards by a handshake. We could have a hearing, a public hearing, to discuss this issue and probably come up with the idea that everybody wants. But I think we have to do it in that way, Chairman, not just to agree. I think we have to have public comment on it.
Yeah, I don't think I apologize if it was interpreted that way. It's not a handshake deal.
Well, I mean, I was just saying it's a standard modification.
It's a formal process,
Yes. Okay,
to
okay.
change.
I'm misunderstood.
Any other questions? Okay, we're gonna go to public comments right now?
We have one public commenter in person, Joseph Otanachar.
That's me.
I'm sorry. So we have 3 commenters online.
Yes.
Okay, the 3 people who signed up are no longer on, so I'll turn it over to the chair for the vote.
Okay, is there a motion on the floor to approve the 6 months variance for renewal request regarding minimum standard 2-05 subdivision B2 subdivision 1I-II psychotropic medication? Is there a second?
Second.
All those in favor? Aye. It's unanimous, and the variance has been approved. And at this point, we'll go to the CHS updates.
Hi, Patsy Yang, Health and Hospitals. So let me also chime in, Bobby, Dr. Cohen, I think it was about 10 years ago, when the city was about to embark on this momentous transition of the health service over to Health and Hospitals. You and I had a conversation, and I think you asked me something like, what did I think the priority was? And I think it was something like, I said something as simple as that the people who need care get the care that they need, and you agreed with that. And we have not always seen eye to eye, but I believe completely that there's never been a wavering on your part, or I hope you understand on our part, to have that as our guiding light. And for that, I think on behalf of everybody in Correctional Health Services and every single one of our patients, thank you. So that's great. Thanks. I think on July 1st, we in writing answered many of the questions that came to the board. I think they're similar to what you requested here. For people who are in restrictive housing, our care is provided on an individualized basis. We schedule people, our patients, for services that they need and request escorts to that. We work with Department of Correction. We escalate, we elevate, and work with the department if there are barriers to care. And people in restrictive housing, we don't adjust the clinical treatment plans because of their housing. We adjust them according to their needs. The access to the health triage line is still there. Whether it's mental health services, social work services, nursing services, or medical services, those are things that we continue to prescribe and request and schedule. So that's one piece. The issue is, the answer is the same for people who are on suicide watch, with the addition that we do conduct suicide watch checks twice every 24 hours. And that is on top of their treatment plans. So I think I'm here more to try and answer questions that people may have.
Cohen?
We've talked about this briefly before, but I just want to raise it in public. In SMU, you have people, we mentioned 4 people on suicide watch.
I think currently we have 1. Today we have 1.
And it's the only place on Rikers Island where you don't have where you have suicide watch in a general population area, or quote unquote general population, rather than an MO, the various kinds of MO units that you maintain. Off the top, I would think it'd be better to have them there. Why not transfer people from SMU to other units that you have available?
So our request for transfer of people to a therapeutic unit is based on a clinical need. The placement in SMU is not a therapeutic unit. So the department is determining who needs to be housed according to those criteria. We do conduct suicide watch checks on people in their housing area if they are in a therapeutic housing unit. That's where our staff are. Those are intentionally designed. We work with the department to make sure that there's the appropriate space for us to have those checks. In a restrictive house, we don't do that. If people are on suicide watch in a restrictive house, they are brought out of that house into an environment where we can actually have a conversation and talk to them and assess them. The same would be with general population. There's 1 person currently today in SMU on suicide watch. We have worked with the department to bring people out for checks.
You're seeing them in the clinic, but not on the floor. Is that right?
Correct.
Hey, thank you. Any other questions?
Thanks.
There was.
Thank you, Patsy.
Excuse me, 1 second. Betsy, did you address the suicide watch as well? You did. I missed that. I'm sorry. If there's no other questions right now, we'll go to public comment. Jasmine will call the names of those signed up to speak.
First, we have Justina Rizwinski, followed by Riley Doyle Evans.
Good afternoon. Thank you for allowing me to testify today. My name is Justina Rosinski, and I am a licensed clinical social worker, and I served as a clinical supervisor on Rikers Island from December 2020 through September 2024, working in the mental observation units and PACE. I previously testified before the board on October 8, 2024, regarding the harmful and unauthorized practice of deadlocking. I have reviewed the board's recent audit report covering April 8th through May 13th, and I am deeply disheartened to see that, despite my prior testimony, community advocacy, and media attention, the practice of deadlocking continues, especially in the units that house individuals with serious mental illness. The board's findings are alarming. Incarcerated individuals were reportedly locked in for reasons such as threatening to throw feces at officers, having lice, or engaging in verbal disputes with correctional health services. These actions are not uncommon in environments where people are experiencing acute mental health crises. While the board reports that it intervened in these cases, we must ask, how long would these individuals have remained locked in if no one had been watching? Even more troubling is that the board found continued failures in documentation. Individualized involuntary lock-ins are still not being properly recorded, despite prior directives and public assurance from DOC leadership. When I testified, DOC representatives stated that deadlocking does not occur in the jails. They claimed a policy had been issued explicitly stating that the practice is prohibited. Yet here we are months later, and the evidence clearly contradicts DOC's public stance. The practice is still happening, it is still undocumented, and it is still harming some of the most vulnerable people in the system. And let's be honest, the audit represents only a limited snapshot. The 6-week window is far too narrow to capture the full extent of the problem. If you want to understand what is truly happening, you must listen to the people who are detained there, to clinical staff, and to public defenders who have sounded the alarm for years. I do want to thank the board for important recommendations issued to the Department of Correction, including requiring detailed documentation and reporting of individualized involuntary lock-ins, eliminating the use of the term deadlock in official records, mandating that staff assigned to MO housing complete 40-hour crisis intervention training, tracking incident level data, including names, locations, reasons, and duration of lock-ins, conducting audits of logbooks and surveillance footage to identify patterns of misuse. However, today we did not hear from DOC their thoughts on these recommendations and how they plan to address this issue. And these recommendations are necessary, but they're not enough. We need more than words and policy memos. We need action. And that means unannounced, consistent visit by the board across all facilities, clear accountability measures for staff and leadership who have failed to comply, public transparency about whether DOC is following through on its obligations, and real investment in training and retention of qualified staff who can de-escalate crisis without resorting to isolation. As a clinical social worker, I know that healing is possible, but not in a system that punishes symptoms of mental illness. Deadlocking is not a therapeutic intervention. It is a punitive and harmful practice that erodes trust, worsens mental health outcomes, and undermines any effort toward rehabilitation. We must do better, and we must do it now. Thank you for your time and continued attention to this critical issue.
Okay, thank you.
Thank you.
Thank you. Riley Doyle Evans, followed by Chris Boyle.
Good afternoon again. Just want to start on behalf of our entire office at the Prisoners' Rights Project at the Legal Aid Society by thanking departing board member Dr. Cohen for his over 16 years of service to the board. Having a former director of medical care at Rikers Island on the board has been invaluable. A tremendous level of expertise and inside knowledge has been brought to the board thanks to Dr. Cohen, and his close attentiveness to the facts and his lived experience in providing care on the island have elevated the board's decision-making and execution of its charter mandate to oversee the jails. We're deeply grateful to this public servant for giving so much to the city and his tireless advocacy for the dignity and humanity of people on Rikers Island. Turning to just some brief comments, there's been so much to say, frankly, at this meeting on a long agenda, but I'll just speak to the matter of the SMU. As has been highlighted by board members, it's really quite absurd for the department to come here and claim that this is not a restrictive unit. People are not only housed in their cells for only for 17 plus hours a day, they're also subject to a blanket practice of enhanced restraints while out of cell, which itself nullifies another board standard, which provides process for people when they're subject to these sorts of restraints. So to the extent that the board is coming before you and, painting a picture of people who are monsters who, well, we have no choice but to restrain them for their bad behavior. If that's true, follow the process, right? There's a process for that. There is due process that the department must follow, and to impose this on a blanket basis to people in a unit based on their housing in that unit undermines the thrust of the board standards and likely violates the law as well. So let's be clear about what SMU is. This is another acronym for the same old restrictive isolation that this department has imposed on people unlawfully for decades. And it's related to the practice of deadlocking that Justina just described, and really is of the same sort of family of oppressive, retrograde thinking that has brought violence to this system since the beginning. The department, through these practices, is making monsters of people. If they want to come up here and describe people as monsters, they need to look at themselves in the mirror and ask, what are we doing to beget this behavior? When you make people desperate, they act out of desperation. Using those acts of desperation to justify their further torture is nothing short of inhumane and disgusting. We hope that this board will take action to rein in the SMU urgently, and to take steps to protect the rights and dignity of people housed there, including by ensuring that the other elements of the board standards that are apparently, admittedly being violated on a systematic basis, that those violations are brought to an end. Finally, I think it's, acknowledging that HHS faces some challenges with DOC to get people access to care. I think, frankly, it's dangerous that these departments are coming before you and admitting that, people are not being rounded in these restrictive units that are clearly causing harm to people. If you've got people in suicide watch, there should be access to care that's readily available because, again, people will harm themselves and will die. It's not news. Statistically proven at Rikers itself. Thanks.
Thank you.
Thank you. Chris Boyle, followed by Dr. Fran Gatellis.
Yeah, I just want to add here that it didn't appear as if it was on the agenda, but there's been a very public failing by the Department of Corrections in terms of their drug testing from this young man that was stopped, attorney that was stopped and then filmed while he was in corrections very publicly and then fed to the press in a way that certainly caused him humiliation and is certainly going to cause millions of dollars worth of damage to New York City coffers. So I would just ask that you take some time to figure out, number one, it seems as if they shouldn't be using whatever testing they're doing, it's not working. That would be the first thing. And the second thing is that it's clearly chilling the lawyers that are going there now, because I'm hearing stories about lawyers that don't want to go to Rikers because they're being stopped by dogs and officers and searched in a way that they weren't before. And there's no call for that because obviously the testing came back negative, and this young man was arrested for nothing. So I would just ask the board to definitely put that on the next agenda and have some conversation about what they're doing over there and how they're conducting themselves, because it doesn't appear as if there's been any follow-up by the Department of Investigation about why they had a camera on the inside, why they photographed them, and who took the test and why this happened in the way that it did, because clearly there was a huge failing. So I would just ask for that. Thank you.
Thank you.
Thank you, Dr. Fran Gatellis, followed by Chaplain Dr. Victoria A. Phillips.
Peace and blessings, everyone. So Fran designated me to speak for her, and so I will. Don't knock my papers over. And so from the Jails Action Coalition, some of us are here today, and from Holt Solitary, we'd like to utilize Fran's time to simply say, Dr. Cohen, we thank you. We appreciate you. Show it, JJ. We just want to honor you and your work. And many people, yes, that's just a little bit of what we could give to you to say thank you from a community of New Yorkers, a community of people that understand that you truly show up and you make the blueprint for what it means to have balance on an oversight board, and what it means to show humanity, what it means to be a man of integrity and be led by a moral compass. I'm not just speaking fluff, you know, I've never been about that. But I think that I say it from all of us and from everybody that's in our coalitions and campaigns. We thank you for standing up and for remembering the people behind the walls who were never seen, never remembered, never even truly thought about without it being about around someone's paycheck or job position. And you always have shown a far more than 15, 16 years. You've given New York City over 40 years of service to doing what's just. We thank you for putting us in your purpose. We thank you for showing up even when leadership might have tried to stifle you and silence you and ignore your expertise in this matter. We, the people, thank you so much.
Thank you so much. Thank you so much. And I don't think I expressed it before as well as it needed to be said. I'm very honored to be up here, but I couldn't do what you're accusing me of doing without all of you, being here. It really is. It takes more than a village. It takes a commitment by a lot of people. We need to grow it. But for me personally, you're what matters, and you're what makes it happen. Thank you.
Thank you. Thank you. Thank you again so much for that. We truly appreciate you and accept your flowers. Your legacy is great, and we thank you for being a part of it.
She's speaking on our behalf at this time now. Okay, thank you.
Yes. I am Chaplain Dr. Victoria Phillips, and I was already signed up on the list to speak. I just want to say, one of the great things that I've found in the spiritual world is with time and experience comes a certain level of mentorship and leadership that I can give back to others. So in the spiritual world, I'm known as a priestess or a chaplain or an auntie. In the community, I'm known as a leader. When I walk into boardrooms and many spaces, people sometimes cringe when I put my hand up. And I'm not frightened by that. That means that they are worried sometimes, usually on what the history it is that I might bring to the conversation. And so, Dr. Cohen, you will be missed, because the expertise and the history that you bring to helping save lives, and we know we can't do it all. And I'm not saying you're a perfect man, because no one's perfect, but you truly have shown up. And I try to model that in a way, right, to do what I can in my capacity. And that's why I'm always fighting to show up and be in spaces and places. And I just want to take my time right now to encourage everybody who's listening, for whatever reason, maybe you're directly impacted, maybe you're someone who works on the island. We all need to show up. We are at a time where our administration, federally and locally, is in shambles. And if we don't look out for ourselves and our community members, we are going to continue to fall short and lose each other. And this is a time where even privilege could be pocketed and put to the side. And think of your neighbor. And I say that because it takes courage to be in leadership. It takes courage to hold others accountable. It takes courage to say when you're wrong or you need to be taught something to do right. And that's why I encourage all of you board members who are still sticking around to lean on each other, to lean on those who have an expertise in the fields that you're making real decisions on, and to hear the people, because it's only those of us who have been through it that can truly tell you what that walk is like. Don't disrespect people. because you don't think they have a certain level of experience or an alphabet letter behind their name to your level of standard. Everyone has some type of connection when it comes to the criminal legal system. And I'm so sick of being on this rabbit hamster wheel. I'm so sick of jumping from topics to topics to try to save someone's life when they all are really truly important. And you literally have the city of New York in your hands by your decisions. Show up like Dr. Cohen used to at city council meetings. Make your staff understand how valuable they are, not just in fluffy words, but by your actions on every day to preserve their well-being and the rest of us New Yorkers. Peace and blessings.
Peace and blessing.
Thank you. That concludes the public comment.
Before we adjourn the meeting, I want to acknowledge Board Member Dr. Robert Cohen for his dedicated service to the New York City Board of Correction. Dr. Cohen has submitted his resignation from the board effective after today's meeting. Today, the board honors Dr. Cohen, affectionately known as Bobby, for his extraordinary 16 years of service as a member of the New York City Board of Correction. Since his appointment in 2009, Dr. Cohen has been a tireless advocate for human dignity, leading efforts to end solitary confinement, reduce the jail population during public health crisis, and improve medical care for those incarcerated in New York City. His decades-long career includes serving as Director of Montefiore Rikers Island Health Services, Vice President for Medical Operations at New York City Health and Hospitals, and Director of the AIDS Center at St. Vincent's Hospital. Nationally, he has served as a federal court-appointed monitor of correctional medical care in multiple states and spent 17 years representing the American Public Health Association on the National Commission on Correctional Health Care. Dr. Cohen's legacy is one of compassion, integrity, and fierce dedication to justice. He represents the very best of what public service can be: principled, informed, relentless, and deeply human. His presence on the board has challenged us all to do better for the incarcerated, for their families, and for the city itself. On behalf of the entire board, I want to extend my heartfelt thanks to Dr. Cohen for his extraordinary years of service. His work has saved lives, changed policies, and uplifted the moral standards of our city. More information about his work and contributions will be made available on the board's website and an upcoming press release. With Dr. Cohen's departure, I will appoint new members to the board's committees at a future date. Thank you to everyone who attended and participated in today's meeting. The board's next meeting is scheduled for emergency meeting. We're looking at July 22nd, and the regularly scheduled meeting to take place on September 9th at 1 p.m. I'll take a motion to adjourn.
Second.
All in favor?
Aye.
Thank you.
The meeting is adjourned.
What committee are you on? That's the only one?